We're on, we're live. We'll call the meeting to order. Welcome to the Joint Ag Committee meeting. We'll do roll call first.
Good morning, Mr. Chairman. This is roll call for the Joint Ag Committee on September 2nd, 2022. Senator French.
Excused.
Senator Kolb.
Present.
Senator Cost.
Here.
Senator Wasserberger. Representative Blackburn.
Excuse.
Representative Clausen.
Here.
Representative Fortner.
Here.
Representative Heiner.
Here.
Representative Larson.
Here.
Representative Western.
Excuse.
Representative Ward.
Here.
Representative Winter.
Here.
Co-chairman Boner.
Here.
Co-chairman Eklund.
Here.
We have a quorum.
Well, welcome everybody to our meeting. And I think we're going to just launch right into Wyoming fencing laws. And come on up, Luke.
Good morning, Chairman.
Good morning.
Committee. Luke Plum, Legislative Service Office. And I put together just a topic summary to discuss the Wyoming fence laws, specifically the statutory provisions. And so these provisions can be found in Title 11, Chapter 28 of Wyoming statute. And so just to begin, the definition of an owner of a fence is a person who occupies, uses, enjoys, maintains, or has charge of an enclosure and is considered, that makes them considered to be the owner of a fence in question. The owner of a fence is the responsible party for any action that is commenced under the statutory provisions for fences and cattle guards. So knowing the definition of an owner of a fence, within Wyoming statute, there are three distinct types of lawful fence, and then there's a general catch-all category. But the first type of lawful fence is a barbed wire fence. And there are specific requirements that the fence must be constructed using steel, concrete, wooden posts, and either be 3 or 2 spans of barbed wire. The posts have to be at least 4 inches in diameter and set at least 20 inches into the ground. And the fence posts can be set no further than 22 feet apart, unless there's a stay in between 2 posts, and they can be 33 feet apart. But those stays have to be equidistant between the posts. And if you have a 3-span fence, it requires the wires spaced out between 10 and 15 inches. And if you have a 2-span fence, it requires a wooden rail on top. I would note here how the statute reads. It doesn't necessarily require that your 2-span fence be 10 to 15 inches apart, but I think it can be read that way. And I didn't have the opportunity to dig very deep into it, but I didn't find any case law on that question. But that's the distinction for a barbed wire fence. A post and board fence is constructed with either 3 or 4 boards between posts that are securely fastened with nails or something similar. Those specific requirements is that they have to be, again, at least 4 inches in diameter, and they have to be set substantially into the ground. And if you're going to do a 3-board fence, you have to be using 1 inch by 8 inch wide lumber that is set apart no more than 10 inches. If you do a 4-board fence, they have to be 1 inch by 6 inch wide boards that are set apart no more than 8 inches. The final type of distinct lawful fence is a pole fence, and these use round poles that are no less than 2 inches in diameter at the small end. The posts can either be upright or leaning, but they must be spaced no more than 16 feet apart, and they have to be securely fastened with nails, wire, or something similar. Now there's those 3 distinct types, but essentially any fence that is declared as strong and well calculated to protect enclosures can be considered a lawful fence. It can be constructed using various materials such as board, rails, poles, stones, hedge plants, etc., to be considered a lawful fence. And they have to be able to resist a breach by stock animals in the same manner as the other 3 distinct types of lawful fences. There is also discussion in statute of a lawful fence that encloses any hay corral. If it's set outside of a field or pasture, those fences have to be constructed of boards, poles, or wires, and they have to be at least 6 feet tall. The posts must be set at least 24 inches into the ground and set no more than 8 feet apart. And if it's constructed using barbed wire, there has to be at least 7 spans of barbed wire. And any fence that is better than that is then the statutory requirements can also be considered a lawful fence. Statute does know that an unlawful wire fence, it basically, if it does not meet the statutory requirements, the owner of that fence can be liable in a civil action for any damage to animals that is a result from the wire fence. You are guilty of a misdemeanor if you maintain an unlawful wire fence with a fine of $5 to $25. The fine increases $25 to $100 for each new offense. And an owner of an unlawful wire fence can be required to rebuild the fence to meet the standards within 30 days of conviction. If they refuse to do so, then it's just a separate offense. And upon each new conviction, it is basically a new offense. And so those are kind of the general requirements of what actual fences are. There are several other general fence provisions, including that fences that are constructed across a public road or a road leading to a watering place must be constructed of boards of poles and extend no less than 8 feet on each side of the middle of the road. If it is a misdemeanor if you do not comply with that provision. A board of county commissioners may authorize lawful fences to be constructed on the right of way of any public road. And that cost of the fence can be distributed either to the petitioner for the establishment of the road, or it can be agreed between the board of county commissioners and the petition, or placed on the owner of any lands who may benefit from it, or just the board of county commissioners can pay for it. Similarly, the board of county commissioners can require to locate and construct gates and cattle guards if it deems it necessary for convenience of the public. And the cattle guards have to be within the specifications of the state highway department. And once again, those expenses can be set upon as it would be for if you're creating a fence along a roadway. Another interesting portion within statute is partition fences. An owner of a lawful fence that is constructed to be a partition fence or essentially becomes a partition fence can require that the owner of the other land that is partitioning pay for half of the cost of the fence. It would be the actual cost or what the cost of the construction of the fence would be if the landowner if the other landowner refuses to pay their half of the fence costs. That can result in a civil action to recover. And the joint users of a partition fence must also share the maintenance costs. And when it comes to land developed for a subdivision, a subdivider is required to and is responsible for the construction of a perimeter partition fence. And this is essentially to be between the subdivision and adjacent land where livestock can be legally run at large. The cost of the perimeter partition fence still has to be shared in the same way, but the adjacent landowner cannot be held liable for any damage to the subdivided land that results from livestock pastured on the adjacent land. It is a crime to willfully or negligently leave open, break down, or destroy any bars or gates that are for the use of the public or any manner for the destruction of a lawful fence. This is a misdemeanor with a penalty of up to $100 fine or imprisonment of 3 months. And then kind of the final big section of fencing statute is the fence out requirement and liability that results from that. So any person who owns livestock that breaches into the lawful enclosure of another person is liable to the injured party for any damages that occurred as a result of the breach. Damages resulting from the breach may be recovered in a civil action, either before a court having jurisdiction, or you can do it through arbitration. For arbitration, each party gets to choose a property holder to serve as an arbiter. Those 2 arbiters then get to choose a third. They're sworn in by the judge of the circuit court in the county where this happened, and they have the ability to examine the fence, assess damage, examine witnesses under oath, and then they're required to create a written report of findings to be signed by at least 2 of the arbiters, and then it's submitted to the circuit court in the county where the damage occurred. The report shall be filed with a judge of the circuit court within 3 days after their findings were rendered. And once filed, the judge is required to enter the case upon their docket, and then it will proceed from there. And when livestock breaches the lawful enclosure of another person, the person who sustained the injury is required to notify the owner of the livestock about the damages and what they estimate the probable cost to be, if the injured person knows who the animals belong to, and if the owner of the animals resides within the county where the damage occurred. The injured person can keep as many animals as many of the offending animals that caused the damage to their property or to their fence, equal to the amount of damages that was incurred. The injured party is allowed to keep those animals during the course of the civil action, unless someone pays for the fence to be fixed. If the civil action does proceed to trial, the plaintiff can be awarded the cost of damages to the fence and the cost of keeping any of the animals in custody. And any judgment for the plaintiff results in a lien against the animals causing the damage. If at trial it's found that the plaintiff's enclosure was not a legal fence or was found that no damage was sustained, judgment will be entered against the plaintiff to include any costs for the suit and damages sustained by the defendant. And if it's found that the defendant in the trial is not actually the owner of the animals, they can be discharged. But if it's found that they don't know who the defendant is, who actually owns that animal, then a plaintiff can still bring a civil action against a defendant unknown and trying to recover some of those costs through if you're maintaining those animals. So that's those statutory provisions of within Title 11 regarding fencing laws. I did just want to briefly touch on one recent bill. It was 2019 House Bill 51, and that was lawful fence standards and county preemption. It was sponsored by the Joint Agricultural Committee, and it prohibited counties from adopting any ordinance, bylaw, or regulation regarding lawful fence requirements and standards in conflict with the statutory provisions I just outlined. It established that these provisions are exclusive within statute and that any county ordinance, bylaw, or regulation would be void, and that a county would not be allowed to require any person to modify a fence that would go beyond the requirements of a lawful fence in statute. This bill failed in the committee of the whole in the House. But with that, that's the end of my presentation. I would stand for any questions.
Questions, committee? I would have maybe a couple, and maybe others can answer it. So it may be a gentleman's agreement or just kind of the way things are. Usually the right side of half of the fence belongs to you to maintain. That isn't anywhere in here. I don't know if it's just the way we do it out there, but if you look at the fence, your right side is the part that you should be maintaining. Doesn't usually work that way. I've got some neighbors that are really good and some that aren't so good. The really good one, you have to get out ahead of the frost to feed them on the fence, but the other ones never see it. But then if you look from the other side, their right side is the part they take care of. That isn't in law anywhere that you noticed, that as far as which part is maintained and how it's maintained.
Chairman Eklund, certainly I think, are you talking about like necessarily like a partition fence or fence between two properties?
Yeah, between.
Yeah, so there's just a requirement that the parties have to maintain the fence. Okay. I don't think that there is any, it doesn't go into a lot more specifics than that. I think it's if you and your neighbor with your partition fence are come to an agreement to take care of the fence, it's incumbent on both parties to maintain it. Okay. So, but it doesn't go into much detail in statute. There are other statutory references to fences throughout the entirety of Wyoming statute, but this is the main area like where fencing is specifically dealt with. Lawful fences are defined, and I looked through statute. I didn't see anything else in regards to maintaining fences.
Okay. Any other? Yes, go ahead, Representative Fortner.
Thank you, Mr. Chairman. Wyoming's a fence out state, so if somebody elects to fence their property out or fence you out, fence their property in, how does that make you liable for their fence? You have no say in that. I think that's backwards. I think if we're going to go down that road, it ought to be a fence in state. That would be the only way you could hold somebody accountable at that the angle you guys are approaching. I think what you guys are asking is you know what, we got large corporations move in, they want to set up fence lines, and then we're going to have to be responsible for half of that fence line and half of that maintenance. It's a fence out state. I think that's wrong. Thank you.
No question in that.
Chairman, if I may just respond,
okay.
that is, I just wanted to let you know, that is just Chairman Eklund, and then Representative Fortner. That's just how how the statutory language reads as of right now. That is the current Wyoming statute. It does require, if you have a partition fence between your property, if it becomes one, it does require the split of that. But that's all it addresses in statute, is that if you create one or it does become a partition fence, then the other landowner is responsible for half.
Yes. Representative Heiner.
Thank you, Mr. Chairman. Mr. Plum, thank you for this white paper on fencing. Question came to mind though, as you was going through this, if a subdivision or if land is being subdivided and they want to put up a fence, a lot of times they put up a very nice fence. So if the rancher is required to share in the cost of half of that fence around the subdivision or along his property line, is he required to pay the cost of that very nice fence, or just the cost of a statutorily required fence? They may put in a big rock wall or something like that. What would the rancher need to pay the cost of half of that wall or fence? Thank you.
Chairman Eklund, Representative Heiner. Really, the only requirement that is in statute, and I will say I did not look into this question to see if it's been addressed through case law. It just requires the cost of the perimeter partition fence must be shared in the same manner as any other partition fence. But it's when the partition fence is required between the subdivision and any adjacent land where livestock can be legally run at large. So I think there is that caveat in statute to say you don't always necessarily require, if you're a subdivider, required to build a fence, but it doesn't go into any specifics about it's capped, it's at this amount or anything, at least that I saw. And like I said, it may be addressed in case law, but I did not find anything to that point, but I didn't look for that, but that's an interesting question.
I can share a little bit. I think stock growers could help us with that a bit too.
Maybe.
In most cases that I know of where a person is asked to share half the cost of a fence, it's based on a 3-wire barbed wire fence. It wouldn't be a rock wall or an real expensive fence of some sort, but they would have a share in the cost if they have to fence, if they're required to fence. We'll get into a little bit of the case law on fence in and fence out, I hope, so that the committee will understand that. Representative Winter.
Yes, thank you, Mr. Chairman. How does the fence out statute, if you will, apply to this for the state of Wyoming? That was my understanding that Wyoming was a fence out state. So how does that relate to this having to help maintain a given fence on a property line?
Chairman Eklund, Representative Winter. Certainly, I think the bigger component of the fence out is that, if you construct a fence and you still have livestock break through, that's when the liability piece comes up. I guess I don't know necessarily if there was a real consideration about the partition fence, about having to share the costs. That I don't know really truly. I think it's more so if I put up a fence and your livestock breaks through, I don't really know if it's, I think it's just that you gain some benefit with a partition fence. Like if it's adjoining your property, you can potentially receive a benefit from that fence. So maybe that was the reasoning behind the intent behind including requirement that, if someone builds a fence, you have to help pay for it. But I don't know how that really is impacting, or if there was any consideration for that for the fence out component.
And I'll just mention, we'll get into that further. And I think stock growers can help us with the understanding. It depends on the species as whether it's fence in or fence out, because we're not exclusively a fence out
That is true.
state. So yes, Representative Ward.
Thank you, Mr. Chairman. How does that apply to the federal lands? We got a bunch of federal lands throughout the state. If the BLM or the Forest Service puts in a fence, are you obligated to split that cost 50-50?
Chairman Eklund, Representative Worth. By basic statute, I think, yes, you could be required to. I don't know how that works in practice. And like I said, there is quite a bit of case law. I wasn't able to get through all of it. I don't know if that's been addressed.
Okay. Representative Blackburn.
Thank you, Mr. Chairman. How would that work with subdivisions that have like 40-acre parcels inside the subdivisions or less? Would that pertain to those folks too?
Chairman Eklund, Representative Blackburn. I think, yes, technically by rule of the statute, if you are creating a subdivision, you are a subdivider and you are legally required to erect a fence, then yes, it doesn't specify anything about like the size of the properties or whatnot. It's just if you're going to be against adjacent land where livestock can be run, you're required to put up a partition fence.
Okay. Was there another question down? Yeah, Representative Portman.
Thank you, Mr. Chairman. So we had a lot of discussion yesterday about school sections, state land. How does this affect those? Anybody that wants to fence out a school section, the state's going to have to be liable for half of that, and they're going to have to be liable for half the maintenance on those fences. Am I hearing you right?
Chairman Eklund, Representative Fortner, I think by basic statute, I think that could be, I'm sorry, I don't know off the top of my head. I do think that there is case law relevant to that. Like I said, I stuck mostly to the statutory provisions within this paper, but that is a good question. I don't have a great answer for you, but I think by basic statute, yes.
Okay, thank you.
Okay. Thank you. Would you be ready, Mr. McGagna, to come on up? And we had a bunch of questions you can answer, I'm pretty sure.
Thank you, Mr. Chairman. Jim McGaggan with the Wyoming Stockbrokers Association. This was a topic that we brought to the committee for interim consideration. Kind of more from a perspective, just needing some cleanup, but maybe by way of a little background, answering some of the questions that were posed here. Wyoming is a fence out state for cattle and horses. We're a fence in state for sheep. So there's that difference that exists there, and it has from the beginning. The other thing that is somewhat of interest is that the fence out principle, which is well established in Wyoming, is not in statute. Early in our statehood, or perhaps even before statehood, under the common law, you were required to fence your livestock in. And Wyoming rejected that common law and established the principle, which has been upheld by our courts, of being a fence out state for sheep and cattle. So that holds to this day, and certainly something we want to continue to hold. We brought this issue forward thinking of just a few areas that could stand some cleanup in the statute. I don't believe our fence statutes have actually been amended in quite a number of time, and types of fences that are built, the way fences are used has changed somewhat. So I might just go through what we're recommending for potential changes, and then be happy to answer any questions on that. The definitions of the lawful fence in 1128-102 talks about a 3-wire barbed wire fence as a wire fence. And it goes on and talks about different types of pole and wooden fences. And then as the previous speaker referred to, there's that provision that talks about all other fences, but says all other fences made and constructed of boards, rails, poles, stones, hedge plants, or other material. As we read these sections together, we believe that it's an interpretation is that while it has all those other fences, that for a wire fence to be deemed a legal fence, it has to be 3 barbed wires. That's our reading. And today, a lot of our landowners, ranchers are working in cooperative programs with our game and fish, with other entities to make fences more wildlife friendly. And often a part of that is making the bottom wire on the fence a smooth wire in order to allow passage of wildlife. And we have some concern that if we're legally challenged, that a 3-wire fence with the smooth barbed wire would not be deemed to be in compliance with the statute as it's written today. Similarly, electric fencing is widely used today. more often maybe for internal fences to control movement of livestock, but in some cases, by agreement of the parties, it's used for boundary fences as well. And on the same principle as we read the statute, that electric fences would not be necessarily deemed to be a legal fence if the issue came up in court. So that's one area in 1128-102 that we're seeking some changes. 1128-103 talks about an unlawful wire fence. Doesn't address any other type of fence for a wire fence. And it says if you build an unlawful wire fence, then you're responsible for any animals that for damage to any animals that cross that fence. So if you build a fence that that livestock, not wildlife, gets caught up in that, and the fence isn't one of those defined lawful fences, that you're liable for damages. Again, if the changes were made in the types of fences, the liability here for the first offense is $5 to $25, and for subsequent offense, $25 to $100. If that's properly defined and you're going to be liable, we think that $5 isn't maybe in today's world a meaningful measure of liability. If we're going to maintain that liability, it ought to be at a more reasonable level in today's world. That's the second area we've identified. The third one is one that's already been raised by Representative Heiner, and that is with subdivisions. Frankly, we have some concern with a landowner being required to pay half the cost of a subdivision fence. Someone comes out and establishes a subdivision in the middle of a wide open area, that you should have to pay it all. But if the law currently requires payment, and if that's going to remain, then it needs to be defined that it's the minimum fence, that legal fence that's required to keep the livestock out, not the high value fences that were referred to in the earlier comments. So that's a third area we've identified. Although we question whether cost sharing is appropriate in the case of subdivisions. A fourth area in the statute that we believe could withstand some attention is in 1128-108C, which provides that if animals breach through a fence onto your land, through a legal fence, that you have the ability to hold on to retain animals equal to the value of the damage, which is probably in the eye of the beholder. So if 5 of my cattle come into your property and you think that the damage that's been done by your judgment is equal to those 5 animals, you can restrain those 5 animals and hold them, take proper care of them until an eventual decision by an arbitrator or a court. And that, a court decision could go on for months, and it doesn't seem appropriate. Obviously, I should be liable for the damage done by my animals, but that you can retain my animals for perhaps months at a time seems a little bit inappropriate. And that could mean that cows are separated from their calves, used from their lambs, etc. And we think that one needs to be addressed. So those are the areas we've identified for just kind of a cleanup of the statute. Another thing that I would just make you aware of, and not suggesting that anything be done with at this point in time, but there's some very interesting and exciting experiments going on today with virtual fencing. Just as you can put a virtual fence to keep your dog in the yard, you can put up a virtual fence to keep your livestock, your cattle in an area, whether it's used to create pastures within a ranch where you can move them around. I was just with someone who has some of this the other day, and sitting there with their iPhone in front of them, they can move the boundary wherever they want, and that motivates the cattle to move with that boundary. And while it's in some of its initial stages, there are a number of experiments going on now, particularly with the Forest Service on some of their lands, where it would be a substitute for building fences. The cost of a mile of fencing today, I hear figures ranging from $25,000 to $30,000. That could make this more attractive in the future. The technology is advancing rather rapidly, and as I visit with producers around, there's some excitement about this. So not asking for anything on that today, just making you aware of it, that at some point we may be sitting back here again talking about revising these statutes to address the use of virtual fencing. With that, Mr. Chairman, I'd be happy to take questions on any of these matters.
Committee, questions for Mr. McGagnon? Yes, Representative Portner.
Thank you, Mr. Chairman. Mr. McGagnon, can you define illegal fence?
Mr. Chairman, Representative Fortner, using the statutory language, I would be able to define what is not a legal fence, and they're presumptively illegal. So if it didn't meet those specific standards, then it would be under statutory language, it would be an illegal fence. So for example, a wire fence would be an illegal fence. A fence that was less than a certain height as is provided for in statute, or the distances between wires were not as provided in statute, would be an illegal fence.
Yeah, follow up.
Comment. Mr. McGagnon, would you consider a 30-inch woven wire fence an illegal fence? Because it can do a lot of damage to wildlife. I've seen it as well as domestic life as well. And I didn't hear that mentioned in statute.
Mr. Chairman, Representative Fortner, the statute does not mention woven wire fences at all. And I think presumptively that third provision that says any other fence that's adequate to hold livestock has been presumed to make a woven wire fence a legal fence. But I don't know that that's ever been tested per se.
Thank you.
Representative Ward. No, okay.
Mr. Chairman, I might add just one other point, if I may. A question Representative Wharf asked earlier that just occurred to me about BLM and state lands. And it certainly as to BLM lands, BLM has not been deemed to be bound by Wyoming's fence law. And if your livestock trespass on the unfenced BLM lands, under federal law, you're deemed to be in trespass. As to state trust lands, I'm not aware of where that's ever been challenged, but the presumption and the way it's operated, to my knowledge, has always been that state has accepted that their trust lands are subject to the same statutory provisions as private lands. So if there's a parcel of state trust land in the middle of your private land and the state doesn't want you, your livestock on it, or a lessee of that land doesn't want your livestock on it, it then is their responsibility to fence it. But as the law provides, you would be required to would absorb 50% of the cost of that fencing.
Chairman Bo.
Okay, thank you, Mr. Chairman. So, kind of piggybacking off the woven wire discussion. I mean, it seems like we have two ways we can work this through our statutes and go through and try and update what is a legal fence every last time a change in that sort of methodology or technology occurs. And so we're going to do it for maybe electric fence, but not woven wire. I mean, which is far more prevalent than, at least anecdotally, I think woven wire is probably more used than anything else I've seen, or a combination of woven wire and barbed wire. So is this the best way of doing it, going through and listing specifically and getting down to how deep the posts have to be, how many wires you need? Or were we better off just keeping, paragraph B? It's kind of a general catch-all saying if it works, it works. If it doesn't, it doesn't. Because it seems to me it's kind of a hodgepodge of things we try to be very specific about. Then there's things that are far more common that we just aren't even mentioned at all. So I'm just wondering if, this sort of hybrid system we have is the best way of going forward. Maybe we should just pick more of it.
Mr. Chairman and Chairman Bonner, that's a difficult question, because either, if we try and define all the specifics and add to those that are already in the statute, do we miss something, or does a new practice come on board? You're certainly right. On the other hand, if we just go on broad language that says any fence that's deemed adequate to restrain the livestock is a legal fence, then you run into the issue of are you fostering future challenges and court battles over, well, was this adequate or was it not adequate? So there may be some advantage to at least at this point in time, to still attempting to define a legal fence as opposed to leaving it open.
So would you support maybe a definition of what constitutes a legal woven wire fence in addition to electric fences?
Mr. Chairman, to simplify, I think in looking at the current statute, the part B, which says all other fences made and constructed of boards, rails, poles, stones, head plants, or other material upon which evidence is declared to be as strong and well calculated to protect enclosures. That language there, if that were maybe just broadened somewhat to say all other fences made, constructed of boards, rails, poles, stones, hedge plants, wire, including both barbed and smooth wire and electrified wire or something like that, that just clarifying that that section applies to wire fences as well as these other fences might be an adequate way to address this, and the simplified way to do it.
Okay, well, we're on the same subject. I'll get to you in a minute. So if we don't get somewhat specific with this, a legal fence that holds livestock in is adequate until it doesn't hold them in, and that can happen with a simple bullfight. I've got a highway fence that's 3 barbed wires and a woven wire fence, and it's just ought to be good for game or just about anything. And then a lane next to it that's a single electric, fairly permanent electric wire that the cattle go through in a bullfight. In the middle of it, the woven wire loses on this steel. They won't touch the electric fence, but neither of them are quite specifically legal, even if the cattle are out, correct? Or am I missing? So if the cattle break through this, and we don't have electric fence listed as a legal fence, we don't have woven wire listed as a legal fence. It's just legal, and as long as it'll hold them in, correct? Or-
Mr. Chairman, that's our reading of the statute. It is today that technically a woven wire fence, really, if it were pushed, and in the case of a woven wire fence, the court might declare, well, it's more than adequate, even though it's not listed. A electric fence could be more debatable there. And so our intent is to say, rather than leave those open, would be to put some language in here that is adequate, even if they're not specifically mentioned, that it's adequate to cover those types of fences. So if we added the thing on wire fences, including electric fences, that would assure that those would be deemed to be legal fences.
Okay, Representative Blackburn, you're good for right now. Representative Clausen.
Thank you, Mr. Chairman, Mr. McGagnon. So I don't know if I'm ready to go down the road of making a 3 barbed wire or 2 barbed wire and 1 smooth wire fence. We got a lot of experience in this, but we built the NRCS fence across BLM, and the bottom, we did use 3 barbed wires, and the bottom 4th was smooth, which I think is adequate, but 2 barbed wires and 1 smooth doesn't necessarily turn livestock. We had a billionaire with a range manager that decided that the top wire should be smooth for wildlife, and it doesn't turn livestock. I don't know that I'm ready to go down the road of lowering the standard to 2 barbed wires and 1 smooth wire, because with experience, it doesn't turn livestock.
Mr. Chairman, Reverend Clausen, I think you have a valid point there. If it can be done in a way that perhaps that if the landowners agree to that type of fence, so what we're trying to say is, if there's an agreement, and it's going to vary, that's based on topography and geography from area to area, but if there's an area where the landowners agree to a 3-wire fence with the bottom wire being smooth, say, or perhaps it's a 4th wire, it would vary from case to case, that they wouldn't be subject to being challenged with having an illegal fence is my point. So I mean, even a 3-wire barbed wire fence, there cattle can certainly breach it under the right circumstance. A calf gets under or something. I don't know where you draw that line, but if it can be worded in such a way that at least where there's mutual agreement that those type of fences would be deemed legal, because I know that I've run into a couple of circumstances where ranchers were anxious to make those type of changes, even two adjoining ones were, but their one concern was looking at this law that, well, if we do that, we won't have a legal fence. Well, if you're all agreeable to it, then, and it promotes wildlife movement and that, it ought to be able to be deemed legal, but. Yeah, follow up.
Thank you, Mr. Chairman, Mr. McGagnon. In one of these cases, it's a ranch I lease, and both of those guys can agree that this is the greatest thing ever, but it still doesn't turn livestock. And then you go down the road to land ownership, the next go round the property line, and everybody agrees this time, and somebody sells it, and now we're in this. We have this fence that's a standard that doesn't turn livestock. Everybody agreed that it would, but it doesn't. And then you end up in the same scenario where you have liability issues because nobody agreed, or even the same people agree, and then 5 months down the road, they're in a little bit of a squabble, and now nobody agrees because it didn't work. It's a great idea. I mean, I think we're walking a fine line here when we change down.
Mr. Chairman, Representative Clausen, I guess what I would say is that I think even if we added some of that in section B, that you're protected by the rest of the language there, which says, which upon evidence is declared to be as strong and well calculated to protect enclosures and is as effective for resisting breaching stock as those described in subsection A. So if whatever type of fence you built wasn't deemed to be as effective in resisting breaching stock as those described in section A, then you could build a legitimate argument that it wasn't a legal fence.
Senator Cole.
Morning, Mr.
Morning.
McGagnon. Question, I want to circle back on the subdivision issue. Are you aware of any past or current legal litigation involving a cost sharing incident coming up because of a fence that separates a subdivision from wildlife or livestock?
Mr. Chairman, Senator Cole, I'm not aware of any current issue. I'm aware in the past where there have been certainly disputes over that. I can't recall as I sit here now whether they led to actual litigation or not, but there were disputes when a subdivision was created, and in part it's come when the subdivider didn't understand and assumed that the surrounding livestock owner was responsible for building the fence. That was clarified that no, they're not. It's a fence out state. And then the subdivider wanted to fence the perimeter of the subdivision, and in a manner that the adjacent landowner felt was excessive. You know, if they said, well, 3 barbed wire fence is adequate, so that's all we're willing to pay for. And the subdivider said, well, you know, 3-wire barbed wire fence around the subdivision is clearly unacceptable and unattractive, and we're going to do something more. There have been those type of disputes. As to whether they were eventually resolved or ended up in litigation, I don't recall.
Yes, Senator Costa.
Thank you, Mr. Chairman. Question for you that maybe you can answer, because sheep are fenced in. Is the other landowner required 50% on that, or is that strictly up to the owner of the sheep?
Mr. Chairman, Senator Cost, that's a question I should have the answer to, and I don't have the definitive answer. I believe that in that case, the owner of the sheep is required to bear the full cost because they're required to fence their livestock in, but I've not researched that.
Yeah, hang on just a second. Representative Blackburn.
Thank you, Mr. Chairman. Mr. McGagnon, other than sheep, is the whole state of Wyoming a fence out state? Is everything fenced out? Or are there certain areas that have to be fenced in?
Mr. Chairman, Representative Blackburn, except for public lands, the whole state is fence out. The other exception I would make that there may be, within communities, I mean, municipalities may have different rules that would apply, but as far as the outside of municipal boundaries, the whole state is fence out for cattle and horses.
Follow up, John.
Yeah, follow up.
So Mr. McGagnon, what about state highways? I thought that is state highways considered public? So they're fenced in on state highways?
Mr. Chairman, if YDOT or county on a county road or YDOT in the case of state highways chooses to fence that highway, then they have fenced the cattle out. But the adjacent landowner, livestock operator, is not required to build a fence to keep livestock off of the highway. And that's why we have areas in the state that you'll see the sign say open range. YDOT or the county, as the case may be, did not choose to build a fence. So it's open range. Livestock are free to roam on the highway. And if a traveler on the highway kills livestock, they're deemed to be responsible for the damage.
Thank you.
I'd have a question on that while I'm thinking of it. If there is a fence and the livestock breach that fence onto the highway, are whoever hits the livestock, are they liable for the damage?
The livestock owner in that case would be deemed to be liable unless they could establish that it's a state highway, that YDOT had failed to properly maintain the fence.
Okay, but if they broke through the fence,
If they broke through a properly maintained legal fence, then the livestock owner would have liability, is my understanding.
really? Okay, we'll have to talk about that a little more because I'm unclear on it. Representative Heiner.
Thank you, Mr. Chairman. Mr. McGagnon, I'm surprised, frankly, a little bit of the great detail that this statute has for fencing. Obviously, this has been an issue in the past that they had to put it all in statute with this clarity. So with that, I'm also a little surprised that all of my life I've heard that Wyoming is a fence out state, and you mentioned that it's not codified. Do you feel like that we need to strengthen that a little bit and put it in statute that we are a fence out state, or it's just kind of a gentleman's agreement right now? Is it something that we need to put in statute?
Mr. Chairman, Representative Heiner, well, I would say it's more than a gentleman's agreement. It's established legally through the court system. So it's more than that. And what you've brought up is a debate I've had, at least in my mind, for years. I'll be very honest. I think if we were to propose to put it in the statute, we're going to open a hornet's nest. And it's well established. It's respected in the court system. It's understood by everyone. And our position would be leave well enough alone.
Right, was there another question down here that I'm missing? Guess not. All right, committee, are we done with Mr. McGagnon for now?
Thank you,
Let's-
Mr.
let's
Chairman.
stand by.
Appreciate it.
So while you're here, so if we were to try to clean a little of it up, like say, woven wire to include it into it, electric fence, do you want, the woven wire 3-wire deal is a highway fence that I've got, and like I say, you could slow a tank down with that woven wire fence, but the electric fence will keep them in. So it oftentimes is a better one if the power's on. Do you want just electric fence period? Because electric fence is being constructed all over the place to temporarily keep in livestock on corn stalks and irrigation areas. Should we make a distinction as to permanent electric fence or just electric fence as part of this inclusion of legal fence? What's your opinion on that?
Mr. Chairman, 2 things. One, I think we don't want to try and define everything. That's why I think some change in this subsection B to include wire fences would be adequate to cover the woven wire fence. As to the electric fence, as long as it's there when it matters, when there's livestock there, whether it's permanent or whether it's put up during a grazing season or moved after, I think from this perspective is immaterial.
All right, but it would be your opinion that we should include electric fence as part of legal fencing, a legal fence.
Mr. Chairman, I do believe
Okay.
that we should, yes.
All right. Okay, well, one more question, Senator Cole.
Thank you, Mr. Chairman. Mr. McGagna, back on subdivisions. What would your opinion about doing some modification to that fencing rule that we currently have? Where the maintenance would be bared by solely by the subdivision owner. But any damages occurred to that fencing by livestock would be bared by the owners of said livestock to repair the fence. That way, maybe it could get out of the realm of cost sharing for this maintenance or repair. So it would compel the subdivision owner to maintain his fence, yet and get you out of the whole quandary of cost of said repair of unknown fencing. What were your thoughts on that? What do you?
Mr. Chairman, Senator Cole, I think we would be comfortable in looking at an approach where a subdivision fence, constructing and maintaining the fence would be the responsibility of the subdivider. And if there's a breach of the fence, and it's a legal fence to begin with, and then there's a breach of that fence by livestock, then as is already provided in that one section, the livestock owner should be responsible for damages, whether it's damage to the fence or damage to whatever lies within that fence on the private property, as long as it was a legal fence properly maintained.
Thank you, Mr. McGann.
Thank you, Mr. Chairman.
So we have Farm Bureau. Well, I'm sorry. Okay. Sorry. He'll be back. I'm pretty sure.
Mr. Chairman, Committee, Brett Moline, Wyoming Farm Bureau Federation, in the danger of showing ag unity on some of the issues. Agree that perhaps the fines should be increased. You know, those aren't much money now. They're not much of a deterrent. In a little bit back on the fence in, fence out, as Mr. McGagna said, the old English law is that everything was fenced in. And then you came to the west and it became fence out. If I understand it right, Wyoming is only fence out for cattle. Sheep and horses are fence in. And I read this somewhere, and I think it was on the livestock board website, but I read this, that the theory behind that was cattle were free ranging. Horses and sheep were herded. So it was that responsibility to keep those animals on your property. Cattle were, if you didn't want them, you had to fence them out. Visiting with my dad, you know, the way things worked on the fencing, like with some of the neighbors that didn't have sheep, we did. So we shared the cost of the fence, but my grandpa wanted woven wire up. Grandpa had to pay for the cost, the added cost of the woven wire, and then maintenance was shared. Some neighbors it was shared quite well, some neighbors not at all. With one neighbor, it was actually, instead of half and half, it was every 30, I believe it was 30 rods. That's old law, that you every so much distance. And I asked Dad, why did we have to do all the work on there? He says, well, we want it done right. We had to do it. Yeah, I digress on that. I do share some concerns about opening up what is, you know, making it more specific, what is and what isn't a legal fence. In visiting with my members across the state, we haven't had any issues of what is and what isn't, excuse me, a legal fence. There's so many dependencies on it. I know if you want a wildlife friendly fence, typically that's pretty friendly for especially calves to go back and forth. So in some areas, that's not very well accepted, but it was on a completely separate issue. A senator mentioned that when you start listing what is and what isn't, even if you have the other catch-all category of any other, that there is concern that if you don't have it listed, will it be construed that, well, they didn't list it, so this isn't on that list, so it's not acceptable. My position is that the any other covers that. It covers the woven wire, it covers steel posts, it covers electric fence. It all comes down to, is the fence good enough to keep the animals at home that are supposed to be at home and to keep the animals out that are supposed to stay out? One of the hardest things on fences is wildlife. Deer, antelope can be the worst, but then that's the state's livestock. So it's the individual landowner that takes care of that broken wire, broken fence. So I guess our position is that when it comes down to defining any other, the statute is probably pretty good. If we start getting too specific, since it's not listed, will it be acceptable? But it comes down to, are you keeping the animals where they belong? And that depends on the animal. That's the way the good Lord made an animal. If they want to, you got homebodies and you got ones that don't want to stay home. The ones that don't want to stay at home are typically somebody else's problem, regardless of how valuable they are. With that, Mr. Chairman, I would sit for any questions.
Committee questions. Representative Winter.
Yes, thank you, Mr. Chairman. Mr. Moline, I'll ask you the question I was going to ask Mr. McGagna relative to legal fence relative and how that is applied to sheep, where sheep have to be fenced in and a legal fence is 3-bar wire is what I understand. And we all know that 3-bar wires won't hold sheep very good. So do we need to address that in your opinion?
Mr. Chairman, Representative, I'll fall back on that any other, and as on my statement, are the animals staying where they need to be? That's why sheep are fenced in, because they were herded up until that was quite common. But if the fence isn't good enough to keep an animal in, that's the responsibility of the sheepman to keep them in. As I said, the way it worked with my grandfather and my great grandfather is they shared the cost of the fence. If you want woven wire, you had to pay that extra cost. That's how it worked with those neighbors, and that is a neighbor by neighbor decision. So,
Representative Heiner.
Thank you, Mr. Chairman. Mr. Moline, you mentioned that in the West, we've kind of embraced this fence out state or policy. Is that common in other states as well besides Wyoming? Do they have a fence out status in other states here in the West? And if so, do you know if any of those states have codified that?
Mr. Chairman, Representative, I don't know for sure how many of the other states, I believe most of the Western states have I would call it more than a policy, because as Mr. McGagna says, it's case law. So it's more than a policy. It's a law. In the Western states, that's what we've embraced. If I understand it right, you get to Nebraska and shoot, it's half and half. Eastern Nebraska is everything's fenced out. Western Nebraska is fenced. But the state is split. South Dakota, everything is fenced in. So the different aspects of different states. I don't know specifically how it's gone. I agree with Mr. McGagna. I think, case law works. I have concerns about trying to put it in to codify it. But with all the fencing, it all depends on the individuals. Was, my family's ranch, we've got 6 different neighbors and 5 of them are great to work with. Well, 4 of them, 2 of them aren't. And that's the way the world works. Where I live, just south of Laramie, I have a whopping 35 acres. And when I went to the neighbors, at that time, my sons and I were raising sheep and they wanted to go wildlife friendly. And I said, no, because if it's wildlife friendly, it's sheep friendly too. And I don't think you want my boys of sheep up eating your garden. Wouldn't bother me, it's free feed, but a little bit. But no, it depends on how well you work with your neighbors. That's what they agreed that we would split the cost of the fence. We used 38-inch high woven wire with 1 barb on top. We agreed to it, and it still seems to be wildlife friendly because I get a lot of pronghorns in on my acreage. So, but it kept the sheep home and it kept the neighbors' horses and cattle out. But that was an agreement, we sat down and talked about it, and that's the agreement we came up with. And that's, probably 90% of the time that works well. A little bit on the, if I understand the issue with the state highways, it's the state puts that on their property. It's not on the boundary, it's on their property. And they have responsibility for the fence. So if you border the state highway, they take care of the fence. In emergencies, we had to change the law a few years ago that in an emergency, the landowner can go fix that fence. For an example, a car runs through the fence, livestock are on the highway. The landowner, or at least whoever controls the land, can fix that fence. On county roads, at least in my knowledge, that's the responsibility of the landowner. The counties have no responsibility for maintaining or building those fences.
Yeah, Representative Portner.
Thank you, Mr. Chairman. I believe when we strengthen these kind of laws and we're cementing a hardship on those that is already struggling in the ranching community to maybe build new fence, come forward and take part in fences that they really didn't want in the first place, but some rich guy moved in and now they're responsible for half of that fence. I think we just need to move back to the gentleman's agreement part of the side of things. And if push comes to shove, then let the court systems take it. But I think when we cement this kind of stuff into law, there's no room for the people that's just barely getting by to survive, especially with the price of materials now and the economy the way it is. I don't see where this would be an advantage to anybody out there right now. Thank you.
Mr. Chairman, Representative, if I remember right, when we tried to get this through, that the subdivision, that the adjacent landowner, if they had livestock, was only responsible for a usual and customary fence. I can't remember exactly how we worded it. That we supported that with the idea that we didn't want to have to pay for a beautiful brick fence for 2 miles along a subdivision. We agreed we have a responsibility to share in the cost, but nothing, I don't know the right word to use, extravagant, something over and above what it needed to take because we want to keep our livestock home. We want to keep the neighbors' livestock out, but the way it would read now is, I'm a little unclear on if they wanted to put up 2 miles of a beautiful brick fence, who would bear the cost on that? I think the gentleman's agreement would work, that perhaps the rancher would share in the cost, but only of a fence good enough to keep their livestock. But sometimes I'm trying to word this very delicately, to have a gentleman's agreement with an MEN rather than MAN. That's plural. And sometimes one side of the fence isn't.
Senator Cost.
Thank you, Mr. Chairman. In listening, this is kind of getting even more confusing. I listened to you and you say fence out cattle and horses. I'm sorry, fence out cattle, fence in sheep and horses. When I was always growing up, it was you fence out the cattle, you fence in the sheep. In reading a couple of things, but not in statute, it says you need to fence in sheep, you need to fence out cattle and domesticated bison. I'm like, okay, I've not heard horses in any part of this. I've not heard of bison until all of a sudden that popped up in somewhere. This seems like we could get into a real rat's nest here real quickly.
Mr. Chairman, Senator, and not having the statutes in front of me, bison can be a dual class. They had potentially, there's two classifications of bison. One of them, they're wild, and the other one, they are considered domesticated. And if they're domesticated, for an example, the ranch in between Gillette and Wright, those would be considered domesticated, I'm assuming. But then I believe they're essentially considered cattle, and you'd have to ask the livestock board or the game and fish how that classification works. But Senator, Mr. Chairman, Senator, it is a very complex issue. And as I stated before, most of the time, with most of the neighbors, it works. If all of a sudden, bulls get to fighting across the fence, well, I can't, Brett, I can't make it today. Well, I'll take care of it because it's got to be done. You got to keep the animals where they belong. But it comes down to the neighbor. And as I said, with our 6 neighbors, 4 of them are absolutely fantastic. One of them, we had a 3-generation disagreement with. But part of it comes down to education. Do they understand? For an example, one parcel that we border, it was my grandpa and his brother, they vacated a county road easement along a section line. And my grandpa let his brother, my great uncle, have all the land. The agreement was on that border fence, the ex-Hart Ranch fixes no fence on there. That's on the deed, that's written down. So those are some of the idiosyncrasies you get into. But as Mr. McGagna pointed out, it's down in writing. People agreed to it. When the new people bought that, my brother says, I ain't putting a penny into that fence because it's it was an educational process. And I think that's what happens to a lot of people when they move in. They're ignorant, but they're educatable most of the time.
Yeah. So I would add a couple things before I forget it, and it's not necessarily a question, but so we can clear up some of this, Senator Costa. I believe it's cattle, bison, and yaks are all.
I forgot yaks.
Yeah, yaks are in there too. We've dealt with yaks in the earlier committees, but anyway, that we can clear up, which are, I thought that the horses were a fence-in animal too, but that I'm unclear on it. There's basically the BOCES animals that are the fence out. We can get that clear by the next meeting when we might be dealing with this more specifically. Nebraska, I'm pretty sure they're a fence in. And I border eastern Nebraska. But now, western Nebraska. Eastern Wyoming does, and so we have to deal with that. You're probably thinking of brand law. It extends clear over to a line on the east side. And something that ranchers need to know is their liability insurance is essential, because you get into a lawsuit and you just don't know what's going to happen. So irregardless of what we do with law, producers need to protect themselves with a good coverage of liability, because anything can go to court, it seems like these days. So those are my 2 cents, but I appreciate your information. Is there any more? Are there any more questions for Mr. Moline?
Mr. Chairman, you're right about the split. It is on the brand inspection. South Dakota is the same way. Missouri River is the dividing line.
All right. Thank you, sir.
Thank you.
Do we have other? Come on up, sir.
Mr. Chairman, members of the committee, I'm Sean Sims with Sims Sheep Company. Don't let that name confuse you. We also run cattle. One of the things, we're talking about the sheep and being fenced out, or a fence in portion of that. We do have herders, and we have generally large landscapes that we herd these sheep on. The problem, or the concern we have lately has been, we've seen a huge influx of out of state, mostly California, to tell you the truth. We're collecting a bunch of them, but they are buying up sections of land, splitting them into 40, 35 acre ranchettes to get past the subdivision laws, and everybody buys their piece of heaven. And it sits right inside of a big allotment. Most of them don't want a fence, because then generally on every side of this is a federal section. So you have all sorts of, however polygons they drew up their little lot and their piece of heaven that they purchased. And as a sheep producer, how do I fence one out when the next one we don't know, and the cost of that? So these subdivisions coming out in these big landscapes are a huge issue for the sheep side of it. Now, the cattle side, I can just say, we'll build a fence, but you're paying for half of it. So how do we get past that discrepancy? And most of it, like on a rancher to rancher, neighbor to neighbor, our traditional neighbors' fence is just decided upon, and if it's a legal fence and I want 2 more wires to keep sheep in, or I want to put net, that I can bear that cost. But when I'm having to fence little areas, and another nuance to that, talking about building a rat's nest, is we'll have one that doesn't want any livestock on, the next one wants to lease you. So do I get a fence, or you to lease their ground? So do I get a fence the one property in at no cost to the property owner? I think that's kind of inequitable on the sheep side of this. But then again, I could just say, okay, we're going to run cows there and kind of remedy that. So there is some inequity there. The 35, if I go start fencing, we had one incident where I went and decided I'd fence them out, and they did not want a fence whatsoever, because they wanted to be able to recreate right through the fence on the public lands. So there's a lot of issues, and I don't have any real good answers. The inequity between the sheep and the cattle portion of it, though, is a concern of mine. I know it's not across the state, but it is a concern when they come out in the middle of one of these BLM allotments, which is a lot of times we're in the checkerboard. So there's private that you take exchange of use on, and the BLM, and then they're wanting to fence, and I'm the BLM permittee. And I can tell you how this turns out. You generally are bearing the cost of that because the BLM won't. So on the state land, I've never run into that issue, because generally they're surrounded by BLM ground also. So that's generally not an issue. And we run our sheep on large landscapes. They're fenced on the edges. We usually, are in charge of that, or it's a state highway. So we have no problem fencing, but when they come right in the middle of us, that's when it becomes an issue. And some of this was old railroad ground and some Anadarko and somebody's homestead. The new owners, too bad the state couldn't pull that deal up. The new owners, we're yet to see how they'll react to these types of things. Anyway, with that, that's my concerns, Mr. Chairman, members of the committee. I'd stand for questions.
Yeah. Senator Cole.
Thank you, Mr. Chairman. I guess I'm kind of confused on why people in your position running sheep in this case and cattle are amenable to half the price of a fence around a subdivision. I guess I'm a little shocked. Could you explain why you're in favor of paying for half of that fence and you think it's equitable? I don't understand. Could you help me?
Mr. Chairman, Senator Cobb, I don't think it's equitable, but that's what the law says now. That's how we've acted in the past. I mean, I think when you subdivide ground and you move housing and people out on that ground, you're having an impact to the already existing usages. They should pay for that impact. But the law is what it is right now, and that's what we have to do to be able to operate.
Representative Clausen.
Thank you, Mr. Chairman, Mr. Sims. So I'm clear in my head, some of the issues you have are with the 40 acres, they're not legal subdivisions, they're just subdivided, right? So then you don't fall under they don't have to fence and they don't have to pay their half. So I'm clear.
Yes, Representative Eklund, Representative Clausen. That is why these large landscapes are being or for lack of a better word, subdivided. They're not an actual subdivision that's got to go before subdivision review and have those concerns addressed there. So it's a way to get around, and generally they're 35 acres and larger to not get in that subdivision deal. And what it's doing is eating up a tremendous amount of ground for a small amount of housing. And I understand people want to have their ground, and that, if they can afford it, I guess they can do it. But I mean, that's a whole other issue, is how we try and control these for lack of a better word, uncontrollable subdivisions that are just devouring this ground. And a lot of them are in what I would class as poorer type range ground. They're not your mountains, they're not your forested ground, they're sagebrush and deserts. And these people come to Wyoming and want to live the Wyoming dream, and good for them, but it's causing some impacts as far as producers on these landscapes.
Chairman Boner.
Okay, thank you, Mr. Chairman. Thank you. Good to see you again, Mr. Sims. So if I understand the concern correctly, would that be addressed if along the lines of some of the other proposals we've heard, to clarify that, say, the ag producer would only be responsible for what would have been the cost of a legal fence and nothing more? And I'm also confused looking at the statute as to why what you're describing does not qualify as a subdivision, where the definition of subdivision has nothing to do with the level of acreage. So I'd have to learn a little bit more about that. It's probably something that we could delve into, but I'm assuming that so the question is, with that, clarifying that statute, would that address the concern?
So if I understand your question correct, or Chairman Eklund, Senator, if I understand your question correctly, by addressing the subdivision rules or how they'd fence.
Well, right now the statute says that with the subdivision, you're still on the hook for half the cost. And so if we made it so that you're only on the hook for half the cost of a legal fence, would that address the concern? And if you want to go above and beyond, if the subdivider wants to go above and beyond, have a nice brick, fence, and that cost is on them.
Well, I think that would help, and that's kind of what's going on. But the problem we do have is we'll have a border of a mile long between a BLM or another private section, and the one wants they don't want any livestock on their portion of the ground. But I only touched, say, 1/8 of a mile. with mine and the rest are other owners and they want the livestock. That, I mean, it's a whole rat's nest. I don't know how to better describe it. You run into one scenario after another and we are capable of herding the sheep off of them, but the cattle are, and one thing I'd like to mention, when we herd the sheep off, that limits our use of our surrounding ground because you can't let them come right up to the property. And a lot of these have no boundary markers. They just don't, they know they have a piece of property, but they really don't know where it is. And for me to go out and say, here's your property, it's not well defined, I can't tell where it is, and then I get in trouble for having the livestock on their ground. I mean, there's no fence, but it's still, you get a nasty phone call in the middle of the night, and that's no fun either.
So I wonder if, and just kind of thinking out loud here, if we might have sort of a fence out requirement, not based off the breed of livestock, but based off of the property. You know, so if you are a subdivision, it's on you to keep the livestock out, make that abundantly clear. Not sure all the ramifications of that, but if the concern here is, you know, property that is not being used for agricultural purposes, and maybe that's a good way of defining it instead of, you know, subdivision is currently in statute. That could be something that is, it's pretty intuitive to me, but then again, I'm a rancher, so, but, you know, if you're gonna have your 40 acres, which is just there because you want it, and you're not actually in production agriculture, that it should be maybe an opportunity for clarification that you're responsible for keeping livestock out of your large garden or your large yard. So, okay, just a thought, if you have any reaction.
Representative Eklund, Senator Boner, I think anything that we could do that would maybe not relieve us from the cost of the fencing, but to help that and bring some semblance of order in these large acreage subdivisions. I mean, that's what they are, is a large acreage subdivision, but they're doing it just to get past so they don't have to go through the planning and zoning and subdivision review. And in planning and zoning, that would probably be taken care of. I know the conservation districts do subdivision reviews and they would give recommendations based on those things and type of fencing and that, but any help we could get, it's overwhelming when I start looking at on the sheep side. If I got to fence all these places and keep my livestock out, I'm going to be broke. We can't afford to do that. If we can split the cost of the fence, great. Otherwise, we'll be out of the sheep business and run cattle on those. Well, I won't say out of the sheep business. I'll move the sheep someplace else, and we'll be running cattle, and they'll still have the same problem till they want a fence. And a lot of them are, you know, they come up and they got their money from their house to California. They spent a lot of money. Now they don't really want to spend the money on the fence, and that, you know, fencing, as it was described earlier, is very expensive and time consuming and needs maintenance in the future.
So a suggestion I'd have, and I've dealt with what you're dealing with, mine is a little more formal than surrounding BLM land out in a desert. I'm kind of surprised by some of that, but make it really clear to those people that they're eligible for an agricultural exemption or agricultural designation on the land, and it's a huge tax break. It's got to be, oh gosh, 3/4, 75% reduction in their tax if they allow you to graze it and they just fence out the immediate yard and the part that they're using. But make that clear. I don't know whether you even see some of these people other than hear from them in the middle of the night when your sheep have gotten into the flower patch or something. But I'm feel for you. Go ahead.
Can I respond? Representative Eklund, we do that as much as is possible, and that's portion, you know, we'll have, I don't know, say 5 different landowners, and we'll lease 3 of them under that. Well, then we got the 2 that don't, and then that ensues more fencing to go around those properties. It is very attractive to some people, but we have, like I say, new neighbors moving in who have no concept of what we do, let alone the benefits or, you know, their idea of what grazing is. And they bought their piece of heaven and they like it the way it is. And the way it is, it was grazed. But their vision of the way it is nothing out there. So thank you.
Representative Winter.
Yes, thank you, Mr. Chairman. It seems to me that the county commissioners and the county planning board, whatever they're called, should be approached on this matter. And have you been able to do any of that on your own?
Or Chairman Eklund, Representative Winter, I have not done that. I mean, they know it's an issue, but I don't think at this point I'm not real familiar with the laws, but their response to me, unless it's under 35 acres, we don't control those.
Follow up. Yeah.
Representative Winter.
Thank you, Mr. Chairman. We're experiencing some of this, not exactly the same up in Hot Springs County, but this is where the planning board has to get involved with the commissioners and make some rules that these people have to follow, or these subdividers need to follow, because otherwise, I mean, it's more of a local problem, and it looks to me like they need to address it more, or at least before we do. So, I mean, and I'd be willing to help where I could to visit with those folks, but I think that's the next step, I think, is to push the county fathers to get something done so that they're going to protect you a little bit.
Thank you.
So just on that subject, I'll get to you, John. Maybe we could bring the county commissioners into this conversation when we're dealing with the law bit on the subdivision part, see if they have any help or solution, because I'm unclear on any of the stuff that they do in their planning and whatnot. Senator Cole.
Thank you, Mr. Chairman. Do you run in Sweetwater County, sir?
Mr. Chairman, Senator Colby, yes, we do run sheep in the winter months on the Rock Springs Grazing Association.
So have you had an issue with Sweetwater County with this fencing issue?
We have not. Most of the, it's a lot, that's a vast range, and the development that's happened there usually has a very good fence around it. I cannot speak for the Rock Springs Grazing Association, but as far as a shareholder on that and a permittee out on that range, we don't have those types of problems. Where the scenario we're talking is more, they're large landscapes, allotments of 15,000-20,000 acres. And there'll be these checkerboarded or a homestead that got purchased and it's in the middle or on the edge of them. And so, we're all fenced with cattle grazing in the summer. Most of these are, well, in fact, every one we've had so far is cattle or sheep grazing in the summer on smaller allotments, not the large size of the Rock Springs Grazing Sweetwater County issue.
Follow up, Senator.
Yeah, follow up. Well, so I sat as a county commissioner for 8 years. We have zoning in Sweetwater County. We have never had an issue like you're describing, I think, because we have zoning, and I know that's an option across the state. Some counties don't have much of anything to do with zoning, and others do. So it's really a local issue. But in so much as the subdivision, I'm still baffled on why anybody would have to pay half the cost of a fence that they didn't initiate the said land purchase to cause this to happen. I just find that to be unfair to you. I'll just say it. It looks unfair to me. What's your thoughts, sir?
Chairman Eklund, Senator Cole, I absolutely agree. We did not ask for this. It's a management issue. It's a major pain. And not to mention, along with the housing development, there's a whole myriad of other problems. Of course, everybody's got a couple dogs that they don't know. They got their big free open space, and that causes some issue. But as far as as far as the cost, I feel, but I'll abide by the laws, but I feel that they should bear the cost of those fences. They're coming in as a new neighbor and it's not a traditional use. It's not an agriculture use. They should bear the cost of those, but whatever the law says is what we go by.
We may run into some problems if we were to exempt, try to exempt ag producers out of a fence law that we force subdividers into. That one of the unintended consequences I can think of if we focus in on subdivisions. I think it's worth looking into. A question I have for you, is there much herding that is done anymore? Or is that kind of a thing of the past?
Mr. Chairman, we herd our sheep 365 days of the year. However, there are certain times of the year like lambing and some of these places we're having issues with that we put a lot of money into fencing and we look for coyotes. We really don't herd the sheep because we want them to be calm and out there and raise their, rear their lambs till they get bonded well. It's all arranged lambing, mostly arranged lambing operation, which means those ewes have them on the range. We watch very closely for predators, but generally don't try to herd them until those lambs are big. But the rest of the year they are herded with herders 1 or 2 year round. And when you got one guy and he has to go to camp to have breakfast, lunch, or dinner or sleep, and these sheep or cattle, we heard some of the cattle in areas, they got feet in the nose and they walk, as you are well aware. That's where it becomes a problem. And not to continue to go on, but our labor costs have gone through the roof. So of course we're looking for about anything we can to reduce that labor cost. And that is, keeping them under fence and that. It's very expensive. And then when we have this show up where we're fencing small acreages out of a large landscape, it doesn't work well for us.
Okay, thank you, sir. Oh, we've got another, yep, go ahead, Representative Fortner.
Thank you, Mr. Chairman. Would it help if we went ahead and tried to move the fence in law, not just for cattle or for sheep producers in the state of Wyoming, but maybe for subdivision owners too, in your instance? Would that help you? They need to fence you out, or they need to fence in, I guess. Let's just say that. You wouldn't bear no cost to their fence and they wouldn't bear no cost to yours. And then that way they would be forced to stay out of your lot.
Representative Eklund, representative, on the cattle deal, on the cattle side of things, that's what can and does happen. On the sheep side, if you could change that, I would be forever grateful. It's been we always kind of felt we was a little discriminated against because of the deal, and that is something that's that's what come up through the state. And the herding, herders are harder to find, herders are harder to get. Most of our herders are foreign, so we have that whole scenario to get them here legally and and do that all legally, and it's become very costly. So if we could be on equal footing, would be wonderful. Now, I will tell you, a 3-wire fence probably is not going to hold a sheep back, but at least it is a boundary. Problem, one of the biggest problems we have, we don't know where their property lines start and end. So.
Follow up, I think. I can't see down there. Representative Fortner, are you?
Yeah. Yep.
Go ahead.
Comment. So you're standing here in front of us today. You're probably the only witness we got other than Mr. McGagnon and the Farm Bureau, but you're the kind of people we like to hear from out there, the people that's actually on the front lines getting affected, the kind of guys that come in here and give us good feedback. That's we're what what we're looking for right here. Let's get that out. But so anyways, this whole process is about people like you. about citizens, the people we serve, our constituents, and the people in the state. We need to know what would help you the most if we require a fence in, we got to amend this existing law or do a repealer and get it back out and fix it. Will that help you?
Depending on the outcome, or excuse me, Chairman Eklund and Representative Fortner, depending on the outcome, yeah, it could help very much. I'd be remiss if I didn't have some concern that the outcome might not be where we wanted to end up, but I think about anything we could do to, let me phrase this, we have neighbor to neighbor, old ranchers, existing ranchers, and that generally we don't have much trouble. I mean, we might have an argument over 6-wire or 5-wire on a fence, but we're going to fence and we're going to have a fence or net wire. It's the new in influx of neighbors that don't understand, don't care, legitimately do not care whether we're there or not. They do care if we're on their ground, but then they don't really want to build a fence. Those are the issues that we are really up against, and the cost of that, if I had to fence all them myself, that becomes, I mean, there's no reason to, there becomes a break point that you just can't do that. So
Thank you.
Okay. Yeah, Representative Wharf.
Yes, Mr. Chairman, thank you. I guess to me, I mean, we've been sitting there joking, talking about it, but it seems like to me, maybe you should just buy more cows and maybe do that. I mean, I hate to say it, but to me, I don't know how else you do it. I mean, if somebody is not wanting the livestock on them, but they're just telling you got to fence them out, it sounds like to me you might be better off to just run more cattle in that area until you can get a fence built.
Yeah.
Have you actually thought about that, Sean? I mean, I know, you guys are sheep. I mean, so it is a little bit of a change, but I do wonder if we can't get it fixed, it makes more sense to me to just make a standard statewide, and put sheep in with the same designation of cattle. Because it seems like, Wyoming's changing, whether we want to admit it or not. We are starting to see an influx of people coming into here that don't share our values, don't understand our values, our way of life. And, that's one of the things to me, maybe we do need to standardize that and just say, it's your obligation. If you're going to come in and put a subdivision, you're kind of skirting the law, not doing it as a existing subdivision. You kind of skirting the law. That to me just seems like we should still put that on them, that they're obligated to fence. And those that don't want to fence, because I mean, I don't know. I agree. I mean, if it was my property and I want to put a fence up, I shouldn't have to. But if my neighbor's going to run livestock and they're going to come up and do what they do in my backyard and on my porch, then yeah, they probably, if I don't want it there, I should be the one building the fence. That makes sense to me. But to me, I do think this committee probably should look at what that would do. I don't know how that would impact the rest of the state, but clearly, I know in our area, we do have a lot of sheep producers, and I'm sure you're not the only one being impacted. But I do think the committee needs to look at maybe standardizing all that, where everybody's either in or out. Or we address the fact that, it doesn't matter the size of the subdivision, you put a subdivision in, they're obligated to fence it. Would that help, Sean?
Representative Eklund, Representative Wharf, it would. You asked several questions in that. So going back to the first that I remember, and if I miss any, please remind me. You asked if we run more cattle. We have changed our operation to run more cattle, but the problem we have is we have a sheep operation, and a lot of those permits are BLM permits that are very difficult to change, Forest Service permits that are very difficult to change. And we found that we can do better management running both species on our private and those BLM permits. If I changed to all cattle, I would not be able to run many more than I am because of if we sold the sheep, there'd be no BLM and Forest Service permits, at least in the near future. And I know the forest permits, we can't run cattle that high. So that we have, and we continue to look at things. I mean, if I can make money in the sheep business, I'll continue doing it. If I can't, you can't do it forever. Fencing perimeters, that's be great. That's what I'm looking for. They would help us. When we're piecemealing these subdivisions together, and this guy wants fence, this guy doesn't. I will tell you, we run in an area that a rancher sold, and he mandated that if we can run our livestock on their ground, they can fence off their house, whatever. If they do fence their property, they have to leave 20 feet on the front and 10 feet on each side and 20 feet on the back. So each lot has at least an alleyway. If there's water on their property, they have to leave a water gap that can be accessed by the livestock. On that, we have no trouble there. If you don't want the livestock on, they have to fence. If you want the livestock on there, of course, you can get the agriculture exemption. That's a pretty good carrot for those people, but incentive. We don't have much trouble on that one. Of course, you got new neighbors and the things that kind of go with that, but that type of deal. But that was strictly a covenants on the ground placed by the previous rancher.
Thank you.
Thank you, Mr. Chairman.
So if it wouldn't take too long, because we're starting to get behind, Mr. McGagnon, would you have some thoughts on including other farm species into the fence out law, and what kind of unintended consequences, and how big is this can of worms we're opening up?
Just briefly, Mr. Chairman, certainly as to the fundamentals of sheep are fenced in, cattle out, and Farm Bureau and stock growers are going to have to figure out what's true for horses, I guess, since we have different perspectives. But I don't see any need for change there. Wouldn't advocate any change. As to subdivision specifically, seems to me that it makes sense that the same law ought to apply irrespective of the species of livestock. And our preference would be for a law that says that the subdivider is responsible for fencing out livestock that they don't want on their land. And, as far as the type of fence, that's their choice then. Obviously, the type that might work for cattle doesn't work for sheep, but whatever species is being operated around them, they would be responsible for that. I think the issue that becomes a little more difficult, that I know it's sort of been indicated here, is then you have to define what we're talking about with subdivision. Is it just a platted subdivision? Is it any parcel of less than a certain acreage? Where does that fall? If I divide my 1,000 acres in two, that's not a subdivision, but perhaps, and I'm not familiar with the subdivision laws, perhaps that's clear in the law somewhere, but that would certainly be something that you would need to look at as you move forward in this area.
Yeah.
Yeah, so Mr. Chairman, I would also favor a more tailored approach. Simply, saying that sheep are, fence out would be a huge change with far-reaching consequences outside of the concern we heard today. But that being said, I probably have some questions for, I guess, since Union County commissioners. Is that correct, Mr. Sims? Whoever it is, because I did read that definition. It is quite broad. It has nothing to do with acreage, and so. We need to make it very clear so that the laws are being followed. I think that could be something we could look at as well, but I don't have a fix right off the bat. So yeah, I agree that those two things are probably something we could look at in the petition bill draft and maybe do a little bit of research and find out what qualifies as a subdivision. You know, on the ground, I think the statute's very clear, but apparently it's not to everybody. So.
Thank you,
sir.
Mr. Chairman.
Is there other public comment? Okay, well, huh? Oh, online? Anybody online? Okay, we'll close public comment. Committee, what's your pleasure? Chairman Boner, go ahead.
Hey, thank you, Mr. Chairman. I'll move that we get a bill draft going that covers the following areas. First and foremost, the clarification on oh goodness, where, section 103, increasing the fines. $5 maybe is a little bit low. If that's where you want to go. So we basically just adjust that for inflation, similar to the bill we did yesterday. And then in section 108, excuse me. The section dealing with subdivisions, clarifying that any additional costs above what is required for a legal fence be borne by the subdivider. And also any liability for livestock to get on to the subdivision is with the subdivider as well.
You want those two separate?
Well, we could put them together for now if we want to separate them. That I leave up to the committee. Do we want a broad, all encompassing bill? Or do we want little ones that do little things? And the reason I didn't, I guess my inclination is just have a big one so we can add or subtract things as needed. Obviously, you know, seems like there's some disagreement as to whether we need to adjust the definition. And so that's not in there for now, but it's something we could add later if we just have a broad bill dealing with those changes. So for now, the motion is just a single bill with those two changes to start with. And of course, we can amend as needed at our next meeting.
Representative Larson.
Mr. Chairman, I think the part about a subdivision, the guy dividing it is already liable for the livestock getting in after he's built it. I think it's in there already, but we maybe need to check with LSO.
Yeah,
Mr. Chairman.
Chairman Boner.
That's absolutely correct. It is. And so I think that's something we need clarification on for the definition, why that's not being followed apparently in at least one instance. And so yeah, that's something that could be included, but I don't think we have enough information, or at least I don't, to wonder or to have that be in the motion right now. Certainly if we gather more information and there's some clarity that's needed, I think that's something we could bring as an amendment to the bill draft and something we can have prepared, you know, relatively easy. Just don't have the answer, I think, right in front of us today. So absolutely, that'd be part of my intent to resolve that question, but just don't know what the answer is.
Okay. Committee, so the motion would be to deal with the fencing issue, the fines, the level of the fine, cost of the fine. Clarity on subdivisions, so that may or may not be in it. Possibly research species a bit,
No, the subdivisions,
okay,
what the definition of subdivision is, how it applies, you know,
okay,
or isn't implying as it should.
all right. All right, so that would be your motion on this.
Yes.
Okay, is there a second? Second. Been moved and seconded. Blackburn. Is the committee ready to vote, or do you want more discussion? We're ready to vote. Question being called. All those in favor say aye.
Aye.
Opposed? Okay, that motion passes. Any further Any further? Okay. Well, that's probably all we'll do on bill drafts. I think that we'll try to bring some clarity to fence in, fence out portion of the deal and possibly the unintended consequences of including other species. We're not going to deal with that much. I'm not going to open that many cans of worms. So we're going to take a quick break and try to make it fast committee because we're behind. I'm gonna try to pull us in together. So our next discussion is going to be on the vet techs, and we're going to start out with someone who's online. And the reason is they have a engagement that they really don't want to cancel, and I don't want them to either, and we can. Dr. who? Dr. Tiffany Healy. Go ahead when you're ready, doctor.
Thank you. Can you hear me?
Yes, we can.
Okay. Super. Mr. Chairman and members of the committee, my name is Dr. Tiffany Healy. I'm the president of the Wyoming Veterinary Medical Association. Just interested in filling you in on where we are with vet tech licensure. Technicians will fall under the Veterinary Practice Act, which is why I am speaking on behalf of the WVMA. The WVMA is working in conjunction with the Wyoming Tech Association and the Board of Vet Med to establish parameters for licensure of veterinary technicians within the state of Wyoming. We are just a handful of states that don't have licensure with veterinary technicians. And so we're hoping to get in line with the rest of the country with that. The American Veterinary Medical Association does have a Model Practice Act, so we're hoping to use a lot of their guidelines and existing states' guidelines to help establish the parameters in which licensure would happen for technicians within the state of Wyoming. At this point, we have the WVMA has formed 2 different focus groups. I'm heading up one of the groups. We're a small group of volunteers who will establish just an outlet of standards for veterinary technician licensure. We're hoping to come up with an outline of kind of what we think would work within the state of Wyoming. Start the conversation with our membership as a whole in December, which is when we have our one of our meetings in December in Casper. We don't have our annual meeting at that point, but just present what we have talked about at that point and get comment from the rest of the association at that point. Take all that information and then hoping if we have a concrete plan, have that presented to the WVMA Association membership as a whole to be voted on June in 2023. Our second focus group that we have will be headed by Kinsey Mears, who is the past president of the WVMA. I think they will be looking at other issues and related to veterinary licensure, just ensuring that we are only getting technicians that are practicing under veterinary supervision, and that other folks are not practicing veterinary medicine. So that's kind of where we are. I know my group is planning on meeting in about 10 days. So I am available for questions if anybody has any, but that's the progress that we have made at this point.
Thank you, Dr. Healy. Are there questions for the doc? Thank you.
You're welcome. Thank you.
We appreciate your testifying before this committee.
Thank you.
Senator Emmerich, we used to serve on this committee together a few years ago, and you have some.
Thank you, Mr. Chairman. I'm Fred Emmerich. I represent the WVMA, Wyoming Veterinary Medical Association. I can't really expand too much on what Dr. Healy's already given you, but I can, for those of you who just came in, I can answer questions and try to give you a timeline on this subject. We had had some testimony in June from Farm Bureau. Their problem from their members was they could not get enough large animal veterinarians to do their work. And they wondered if perhaps veterinary technicians might possibly be the answer. The subject grew because of the fact of what is the definition of a technician or a veterinary assistant, and how much are they capable of doing in the area of veterinary medicine due to the changing nature of technology and drugs and et cetera, et cetera. Well, Dr. Healy and Dr. Mayers, the previous WVMA president, volunteered to essentially start a couple of focus groups that would try to address veterinary technicians, veterinary assistants, which are a 4-year education sort, and the licensure thereof. These two focus groups will probably begin their work in September, mid-September, 12th, 15th, something of that sort. And they will proceed to obtain information from the technicians that are in the state of Wyoming, from the college that here, or not here, excuse me, Torrington, that produces veterinary technicians or trains them, and the veterinarians across the state concerning those 3 subjects: licensure, definitions of what they can do of veterinary technicians and assistants. We will be having a meeting in the winter in December in Casper, and that information will be somewhat correlated and brought together as far as what we need to finalize requests and information, at which point they will these two focus groups and myself, I think, will be in contact with LSO to start the procedure of possible legislation. This will be brought to the entire membership in June of 2023. Come into July or so of 23, there will be possible changes and other information concerning, excuse me, licensure of these individuals. And then in August, perhaps go to LSO for final bill drafting. There's really no discussion of bill drafts right now. So I'll stand for any questions that anyone might have.
Committee questions for Dr. Emmerich? Yes. Representative Fortner?
Thank you, Mr. Chairman. I spoke out in opposition against this in June, and I guess my question still remains. As far as I remember, what we was doing was we was going to have these licensed technicians versus somebody that's not licensed. But liability is still going to be there in both instances. Is that the way it works?
The liability would be with a technician situation, licensed or not. If, say, I'm a technician and I'm in your employ for a procedure, that liability remains with the veterinarian who sent the technician to do the work, licensed or not licensed. That does not alter liability. With a licensed technician, however, there is more liability insurance available through WVMA and other avenues, which probably would not change the liability, but would change the insurance. So that would be a plus for the technicians. But other than liability, it's does not change.
Comment?
What
So if I had a neighbor that was doing C-sections and I elected to use him instead of a licensed veterinary or your understudy, are we building in penalties and consequences for people that's doing this without being certified through a college? Is that where we're headed? I hope not, but is that where we're headed?
Well, we're headed, I think, you can do whatever you wish to do on your own animals. You just can't charge for it because then you start violating the Veterinary Practice Act. If you do procedures for Senator Cost, for example, Mr. Chairman, that's between you and the good senator. The Veterinary Practice Act would come into play if you said, okay, Senator, how about you give me $50, I'll do that. That's violation. I don't think a lunch is violation, but you understand the situation that what goes on with your animals is your business. You just don't need to have, you can't have someone else doing work on them unless you want to violate the Practice Act, because that specifies who can practice veterinary medicine and the ancillary parts thereof.
Question?
And well, let me just interject a little bit here. That's a bit off subject because we're talking veterinarians as opposed to veterinarians and others that are doing veterinary work. And let's try to stay on the vet licensing if we can, but
okay,
go ahead.
No, this is just a little bit off of that. So we're talking this law that says that you can't hire anybody other than licensed veterinarian technically. What about yourself?
You can do whatever you wish.
Okay, good enough. Thank you.
Yeah, Representative Heiner.
Thank you, Mr. Chairman. Doctor, thank you for being here, and I understand the difficulty it is to get people to work on large body animals in the state right now. We're under-resourced. Last evening, we had the opportunity of touring their honor farm here in Riverton. What a wonderful tour, what a great facility. They have a lot of large body animals there that they raise and take care of, but they have to contract out for veterinarian service. I wonder if your organization have ever considered entering into an alliance with them for an apprenticeship program or some form to be able to take these veterinary technicians and give them some experience through our own resources like that.
Those are discussions which have occurred through the WVMA and the Board of Veterinary Medicine. But a big percentage of the time, and you can appreciate if you have a group of students that are, say, interning, we have to consider cost, miles, and then miles from the wherever the technician or the veterinary student or whatever you want to say. We have very, very many problems of trying to get enough people to do the work and the vast miles we have to travel. These associations and teaching situations, they have to be mindful of the statute also. What is the veterinarian or the veterinary technician? What are they allowed to do? The veterinarian can practice medicine as he or she wishes. But the technician is under the supervision of a veterinarian. And there are certain things that you can and cannot do, such as diagnose and surgery. Those are two of the primary things that are reserved for the veterinary license holder. So there are ways of getting education out there, like the college in Torrington. But what service or procedure is done is dependent upon the Veterinary Practice Act. So then we got mileage and we've got to move people here and there. And there's not a great deal of margin in large animal medicine. For instance, people will spend exorbitant amounts of money on a dog or a cat. But you start putting $250 into a cow, maybe you're just going to ship her to Torrington again to put her on the truck. So we have to, there's a cost benefit ratio with large animal medicine. And then we have to have some consideration of the Practice Act itself. What procedures, primarily diagnosis and surgery, what can be done or supervised? There is a lot of, and with technology changes, these are a real can of worms at times. They really are. So the idea behind the licensure of the technicians and the veterinary assistants and how it fits into the Practice Act, the association has come to the conclusion that let's do it right and let's do it once. That's the reason for these focus groups and discussion, information passage and all of that sort of stuff. Thank you.
Yeah, Senator Cole.
Thank you, Mr. Chairman. Well, still good morning. I have spoken to the vets I have gotten hold of my area, and they are not in favor of any changes currently. So I just wanted to express that to you that I'm in Rock Springs, Sweetwater County. They're not, they don't think that this is needed. So I just wanted to share that in fairness with what I'd heard currently with you, sir. Thank you.
Mr. Chairman, that is an opinion. And opinions are like cowboy hats. Everybody got one. And so we're taking that into consideration, Senator. Appreciate it. Appreciate your comments. Very much so.
Yeah, I guess I would counter with my veterinarians are thinking that any way they can enhance their practice would probably be a good thing, and that's how they view the technicians. I guess I would say that if we'll see how everything shakes down with the focus groups, but if we have to be cautious. If we don't add value to these people, they'll move to another state, and it may become more difficult to get all the bases covered that we've got in, especially in large animals. I don't know about small animals that much.
Mr. Chairman, that's the purpose. Find out if there is a need, if there is desire, and if there is, move forward. If there is not, stop and go home.
Any other questions? All right.
Mr. Chairman,
Oh, yes.
Dr. Healy would like to speak in.
Okay, Dr. Healy, go ahead.
The reason that we're interested in doing this, and getting technicians licensed, one is to protect the animals, two, it's to protect the clients, and three, it's to protect the professions. And as you have heard, having educated technicians within the profession enhances what we can do tremendously in patient care and on me being able to delegate other things to be completed while I can diagnose and do surgery, as Dr. Emmerich had mentioned. Having them to be able to do all that is hugely important within our profession. So the AVMA is addressing the needs of veterinary shortages within the state, within the country, and particularly in rural settings. They're working on getting more schools on the line that can get veterinarians educated, and some new and interesting programs. Utah State is working on an interesting program right now to try to get some veterinary students actually in with local veterinarians, especially in rural practices, to really be able to help out. So, I think that this really would enhance the profession. We're trying to get more people out in those rural settings, and trying to really to help add value to the education that a lot of these technicians have gone through.
Questions for Dr. Healy? Thank you, ma'am. Okay. Further testimony at this time? Come on up. Were you
One-
done? I'm
No,
sorry.
one other
ahead.
comment, and it will take 30 seconds. In relating to your previous discussion about fencing, my family bought a ranch a number of years ago in eastern Wyoming, where there's no public grazing to speak of. It is all private land. And my dad took me out to show me the ranch. And I said, why are there two fences a foot apart? And he said, well, the inner fence is the one that we purchased with the ranch that we bought. The other fence is owned by a much larger enterprise, and it's a foot inside the property line. And they said, we'll build our own fence, we'll take care of it, and you can go to hell. Interesting thought.
I have a question. Is that fence still maintained by this large entity? That's what
That
happens.
Fence was maintained by that entity, which had a separate crew. That's all they did, is maintain the fence on the perimeter of that ranch.
Okay, that's interesting. Thank you, sir.
Mhm.
Hi.
Hi, my name is Kelly Ferguson. I'm a certified veterinary technician here in the state of Wyoming. I am also the NAFTA representative for the Wyoming Vet Tech Association. NAFTA is the National Association for Veterinary Technicians in America. I know we were discussing a focus group here in Wyoming. NAFTA has kind of done that for us on a national level. I'd like to just share some statistics with you. 95% of credentialed veterinary technicians are in favor of national title protection, and 94% of veterinarians are in favor of national title protection for credentialed veterinary technicians. There's a lot of reasons for that, and I think I heard the word under-resourced here, which I agree. I think in the state of Wyoming, we do not have the resources to care for small or large animals throughout the entire state. But certified veterinary technicians are also underutilized because we don't have title protection. There's a lot of things that we can do that aren't outlined in the Veterinary Practice Act, which we could change that. Also, a statistic from the AVMA says that 30% of veterinarians would like to work less hours. A way to do that, especially in a rural setting, is to have certified veterinary technicians who can do things for you that maybe you couldn't do otherwise without outlining that in the Veterinary Practice Act. Because I don't know if you know this, but if you're a veterinarian in a rural setting, you live there. You live there 24 hours, you're always on call, you're always at the disposal of your community, which is fantastic, but it's taxing and it's tiring, and it's not an optimal thing that veterinarians want after they graduate from vet school, is to go work 24/7 all the time. So one way to get more resources, get more veterinarians here in Wyoming, is to make certified veterinary technicians outlined in the Veterinary Practice Act. I think that would incite new graduates to come here and live here. It would also incite certified veterinary technicians like myself to live here. Fortunately, living in Wyoming, it's one of the more affordable states to, as far as cost of living. So my salary, I can live here. Whereas other states like Colorado, California, it would be very difficult for me to live here, live there affordably on a veterinary technician salary. So, Mr. Chairman, committee, I can stand for any questions you might have.
Committee, questions? Thank you,
Thank you.
Ms. Ferguson.
Mr. Chairman and committee, I did want to just clarify some verbiage. A veterinary technologist is a 4-year degree. A veterinary technician is a 2-year associate's degree. A veterinary assistant is no formal education whatsoever. So I think there was a little confusion with,
Okay,
so I just wanted to
All right.
clarify that.
let's go through it again.
Yes.
Veterinary assistant, there's nothing. No.
Veterinary
formal.
assistants, there's like it's like a CNA. There's a 6-month
Okay.
kind of program that you can go through, but you don't have to.
all right.
A veterinary technician would be a 2-year associate's degree. And a veterinary technologist is a bachelor's degree. Oftentimes, people with a bachelor's degree will get a VTS or a veterinary technician specialty in some sort of specific area.
Okay, and you
Okay.
mentioned NAFTA?
NAFTA is the National Association of Veterinary Technicians in America. So they basically do what the Wyoming Veterinary Technician Association does, but on a national level. Mhm.
Thank you.
Thank you.
All right, we're good, I guess. More. Okay, did you want to come up? You're good? All right, one more online here. Can you bring her in or him in? Oh.
Hi, my name is Nanette Walker-Smith. Can you hear me okay?
Yes, go ahead.
Wonderful. So I am a credentialed veterinary technician, have been so for about 33 years. I'm credentialed in 4 states. We won't go into why. I sent those massive pack of documents to you guys for this meeting and for you to refer back to. There's a definition section in there that will hopefully help you understand the conglomeration because veterinary technicians are looked at differently in different states. We do not have a national credentialing. We have a national exam, which all veterinary technician students must take in order to become qualified to credential in their state once they graduate from school. Veterinary technicians and technologists must take. But there is no national credentialing. They want to leave that at the state level with each state's Veterinary Practice Act, since, as we've already heard here, that we have so many different situations in each state. You know, Wyoming is much more of a large animal state with pockets of small animal and or exotic type things. You have California, which has everything, and so on and so forth. So it's quite variable. In those documents, there's a lot of wording, which is one of the things that Dr. Healy's team is going to be taking on, is looking at wording to make sure, as Dr. Emmerich said, that we are going to try and do this once and do it right the first time. The wording is essential in how the legislation gets passed so that it is understandable and not confusing, hopefully, to the general public, to say this is what each one of these people's responsibilities are and what their tasks and duties are and the specific definitions for those. There's also the discussion of supervision level that we have to address. So for example, with the discussion of having a technician go out to a ranch without the veterinarian, so that would be an unsupervised, but still under the veterinarian. So they're calling the veterinarian, they're having a credentialed veterinary technician go out to the ranch and perform whatever it is. Wyoming already has 4 licensures that they do: the artificial insemination, the brucellosis, and so those things, which are all specifically one thing. If you've got those licensures, those are all things that a veterinary technician can do. So those are already licensed in the state. And obviously those were important at some point to assist that large animal faction of groups. licensing veterinary technicians would take care of all 4 of those items, because those are things that are and can be taught at veterinary technology school. And it's one of those things that the community in Wyoming needs to really put forth to, especially EWC, Eastern Wyoming College, that, you know, we want to really get these folks headed towards, more importantly, large animal. It varies with these vet tech programs, what they're going to be focused on based on where they live. Anyway, with this information, that'll be one of the things that we focus on in this committee, to try and make sure that we cover those things in this Veterinary Practice Act, to make sure that we are being very clear about what a supervised and unsupervised person can do. What this also means is that if veterinary technicians become licensed in the state, then that also means that those that are not licensed cannot do those things under a veterinarian. That also means that they become liable for what they do. This is important because if a veterinarian sends somebody out that is not licensed and something happens, it could be the veterinarian's license that is at risk. Veterinarian still is the one that is supervising essentially, or is responsible for that technician. But licensing a veterinary technician also gives that veterinary technician responsibility to be beholden to whatever the task was. And so, yes, having some kind of insurance through the Wyoming Vet Med Association or something to that effect will help, so that it puts more life into that fact that you're licensed. There are 2 or 3 veterinary technician specialties through NAVTA that Kelly just addressed, that are specifically large animal medicine. So there's large animal medicine, internal medicine, large animal medicine, emergency critical care, and large animal medicine, anesthesia. So these are actual veterinary technician specialists that go above and beyond and get a specialty certification above and beyond their credentialing for licensure as a veterinary technician, to be specialists in those areas. They cannot perform surgery, but they do administer anesthesia. All of us do. All of us credentialed technicians are credentialed to perform anesthesia, injectable, inhalant, anything to that extent. We operate with drugs every day. We deal with patients, wellness care, clients, customer service, lab equipment, assisting the veterinarian with diagnoses every day. We don't diagnose, but we do all of that every day. And what Dr. Healy addressed is the fact that what veterinarians' 3 priorities are is to diagnose, prognose, which is say your animal could have this, this, or this, and prescribe and perform surgery. So they prescribe medications, they perform surgery. Those are the 4 things, sorry, that not 3, 4 things that veterinary technicians cannot do, period. So you can get specific about what they can do, as far as like suturing skin wounds or something like that. But those are the 4 things that licensed veterinary technicians cannot do. Even the veterinary technician specialists cannot do that. That is strictly a veterinarian only task, based on what Dr. Emmerich was saying, as far as this, that constitutes the practice of veterinary medicine. Okay, so that's kind of a gloss over of what's in those definitions. If anybody has any questions about that information at all, please don't hesitate to contact me. I've been involved in the legislation since I was a student in California way back in the 80s. So I've been involved in all of this in 5 states now. So it's very convoluted and very confusing. So we want to make absolutely sure that as Wyoming approaches this, that they do it very well. Colorado just did it and did a really, really bang up job with it. And I'm so pleased that Wyoming is actually approaching it from the veterinary side. When we all work together, it makes it so much easier. And then we'll be able to provide the best we possibly can for the animals, all animals in Wyoming, as well as their pet parents, their large animal stock. This is an income here in Wyoming, and that's very, very important. So there's a lot of things coming down the pipeline with the changes that are happening in Wyoming, and we want to be on the forefront on it, not the behind front. So thank you very much.
Thank you, ma'am. Any questions? Yeah. Representative Fortner.
Thank you, Mr. Chairman. So right now in the veterinarian field, you can use employees without a veterinary technician certification. We pass this in the law. Is that going to prevent you from using other employees that you have on the premises at the time? Or are you going to have to require a veterinary technician to help you call in somebody from outside to help you do your job?
That's a very good question. So usually when those things happen, especially in a state like we have where we don't have enough support in the practices as it stands right now, there'll be a type of grandfather clause usually where you give X number of months or years to folks to go get their credentialing, especially if you have people that have been working in the practice for years. When we started the Wyoming Veterinary Technician Association, we had several people that were grandfathered in because they'd already been working in the practice for 5 or more years at least. And so what their requirement included was getting themselves, they had to put themselves in a situation where they could take the national board exam and pass it. And grandfather in, or we also accepted letters of recommendation from veterinarians to grandfather them in without having to take that test. Now, and then we only allowed that for, I believe that was a couple of years when we launched the association and we started doing the certification. Right now, Wyoming certifies all of the technicians in Wyoming if they want to be certified, and actually a few other states as well, because there are people that are either interested in coming into Wyoming perhaps, or that need to be certified and missed a deadline or something somewhere else. And we have held a set group of about 100 or maybe a little more of certified veterinary technicians for the state of Wyoming, which is pretty darn good. At least it shows that we have numbers here that find value in that because they can say that they're certified. It also includes continuing education that they must complete every 2 years to stay on top of all of the new techniques that are happening in veterinary medicine as a whole. So with that, with what you're asking, Representative Fortner, the part of the fact would be looking at what we have in the state of Wyoming as far as who's employed by all of the veterinarians in the state. And we would probably look at the Veterinary Medical Board to assist us with that, to take a survey of all of the veterinarians. They have premise licenses, so we would be able to do that and find out specifically who has education, who doesn't have education, who's certified, who isn't, and find out what we might base that grandfather type clause on as we write this forward, because that would be in addition of doing the licensure. So let's say this goes into effect, it gets voted in 2023. The licensure starts January 1st, 2024. Then we say there's 2 years, which would be a 2-year degree, 2 years to get them to licensure via online or via a school at EWC or somewhere close by. And then they can be certified in that standing and still be under the supervision of the veterinarian. So there's a little bit of wording that has to go with that. But yes, that's definitely a concern that we need to look at as we go forward with that group.
Question?
Follow up.
So if we're in an area where there's no veterinary technicians and the veterinarians need help, will this be a hardship on veterinarians in the state of Wyoming if this is passed into law?
Well, that'll be a definite question. I totally agree, Representative Fortner, that this is something that we need to find out, because this is going to be something that we have to come up and address. We don't want to come forward with legislation information on something like this and suddenly have folks that feel that this is going to be a complication, and have them, create a problem that, well, what about us that don't have anybody? If they've got family members that are helping them, or ranch hands that are helping them, or something like that, then we need to look at and address this. And this is one of the things that's going to make Wyoming not difficult, but different. So we need to be looking at the states and what they've done that do more ranching, and how they've addressed things like that. So maybe states like maybe Texas or South Dakota or something like that, that have addressed those issues where there are veterinarians that maybe do several distances, but that may not have a whole lot of hands-on. There are technicians that want to go out and be in large animal, but the problem is that if there's no credentialing, there's no utilization. The big thing with technicians is being utilized. They don't want to just scoop poop, shall we say. They want to be utilized for the knowledge that they have. They want the veterinarian to do their job so they can do so that the technicians can do more for the practice. And that includes being utilized, being recognized as far as respected, and be paid for it. So it's one of those things that has to be looked at too. And I think that it will come. It may not be instantaneous, but I think that if Wyoming shows that they can create a Veterinary Practice Act that addresses those situations that you're saying, Representative Fortner, that we can do this well.
Thank you.
Thank you. Senator.
You're welcome.
Thank you, Mr. Chairman. I had a general question on the cost of services. I was thinking about how to word this, but generally speaking, when you have new regulations, obviously different than we currently have, how can you keep the cost down to the end user? I guess my confusion is every time I've seen owners regulations that are new, for whatever reason, there's always a cost increase to the people utilizing the service, i.e. the end user. I mean, how can the vet continue to do the service if all these other regulations are required? Could you help me out with that?
Dr. Healy, would you like to answer to that at all?
Sure. Can you hear me?
Mm-hmm.
So with licensing technicians, the hope is that they are going to be better paid. I think the average cost of a technician right now on what they're paid is probably around $15 an hour. That's a really hard salary to live on. So yes, we do hope in licensing technicians that they will have more value on their service and they will be better paid. However, if they are able to do more things for the veterinarian, then the veterinarian can use their time in other places. And so, I think everything is becoming more expensive. But I do think that by being able to pay our technicians better and have a more livable salary, and again, they're going to be able to do more within the profession, and veterinarians are going to be able to use their time in a different way. I also would like to address what Representative Fortner had mentioned about, existing people that are working within the veterinary profession. What happens to them if they don't have that education or that license? And I think it's important to understand the difference between veterinary assistant and veterinary technician. If folks in a rural setting, if there's not a veterinary technician, they can still have a veterinary assistant. And there are certificate programs that you can do that, but it is also, you don't have to have that. As a veterinary assistant, it is that you are there to assist and do things, but you may not necessarily be placing an IV catheter or running lab work or looking at it underneath a microscope to tell us what you see. So in response to that, no, and nobody's going to be losing their job. It's just we're trying to elevate those with education, so we're protecting their profession and allowing them to do more within the profession than they can currently do.
And I'll piggyback on that. Thank you very much, Dr. Healy. The CVA, or the Certified Veterinary Assistant program, there is a model act for that by the NAVTA group. There are a couple of states that recognize certified veterinary assistants, and they do have it in their practice acts. That is something we could consider. The EWC does have certified veterinary, or they have veterinary assistants that get a certificate if they don't choose to go all the way through the veterinary technician program, and they stop after the first year, then they become veterinary assistants with a certificate. It is not part of the NAVTA Certified Veterinary Assistant program, but that's something we can definitely look at, and that elevates them. So one of the things that Dr. Healy did say was that if you were listening real well, said that means that the assistant's not going to be placing a catheter, not going to be looking in the microscope, not going to be doing these. Who does those things if there's no certified veterinary technician? Guess who? The veterinarian. What should the veterinarian be doing? The veterinarian should be seeing more patients, surgery, diagnosing, and prognosing, and prescribing. That allows, with a certified veterinary technician, that allows the veterinarian to see more clients, do more client interaction and those things, rather than running around doing all the technician work. Okay, so that's where that happens, and that's what she's referring to as far as saying the cost doesn't necessarily have to go up that much. There will be, because there's always those cost changes that occur. But if you use your team more effectively, then the effectiveness of that team brings more back into the practice, because your number of people that you see and number of clients that you see and patients that you see actually increases, rather than people doing things on their own and treating on their own, which may not necessarily be the best thing for the animals. And that's really the whole point here, is we're trying to take care of the best care with the animals.
Okay, so I'm gonna suggest we move on committee, and because we have a lot of material to cover, we're not going to take a lunch break, and I don't want everybody wilting and fainting before we're done. So unless there's any other really important testimony, we're going to deal with this when we have a bill draft, and these questions can be answered then. Thank you, Mrs. Walker and Dr. Healy. Okay. No further comment. Okay, let's move on to slow moving vehicles. LSO. Come on up, Luke.
Thank you, Chairman. Yes, Luke Plum, LSO, here to discuss 23 LSO-0135. This is slow moving vehicles amendments. I just would like to note right off the top that a lot of this was based on Ohio statute that we discussed at the June meeting. And so going through is, I'd like to note that the big change is the addition of a speed identification symbol with the slow moving emblem. It's included as a basic requirement for the vehicles in compliance with the American Society of Agricultural Engineers. And so that is one of the conforming amendments here. But then there's several new sections that have been added that are added by this bill. The first one is that vehicles that are manufactured and operated after July 1st, 2023 must meet these requirements. Here there was my understanding there was discussion at the last meeting about grandfathering in older vehicles. And so that's where that language manufactured and operated comes in. And I think that just is it might be one of the recommendations provided from Mr. Kennedy, and might address a few of those as well. But in this case, any piece of equipment, implement, special mobile equipment that can operate at speeds over 25 miles per hour requires a slow moving vehicle emblem and a speed identification symbol, which must indicate the maximum speed a vehicle can go. Operators running equipment on a street or highway over 25 miles per hour must have documentation provided by the manufacturer on the speed that the equipment can reach. The next new section, K, is that it requires for when any combination of farm tractor and a towed piece of equipment that normally operates at speeds over 25 miles per hour must have the slow moving vehicle emblem and the speed identification symbol. And depending on the towed equipment, if the towed piece of equipment obscures the emblem and symbol, they have to have the emblem and symbol on the towed equipment, not necessarily required on the tractor pulling it. If the towed piece is not obscuring the symbols, then it can go on either or both of the pieces of equipment. And I just did want to note a couple things, and I know Mr. Kennedy will have an opportunity to come and discuss his proposed amendments that was provided to the committee. I just thought it may be worth the time to mention, I know certainly on the end of page 3, in terms of lines 20 through 22, that is where it does state that it specifies that if the towed unit or any load thereon obscures the slow moving vehicle emblem and the speed identification symbol on the towing unit, that is when there's the requirements that if there is obscured, it be on the towed piece of equipment. I believe that their recommendation would be to delete that requirement as in terms of if the towed unit is obscuring the emblem or the speed identification symbol. I think just that is one of the differentiations here that is made in 1 and 2 of K, the subparagraphs there. And I think another notable piece is that there's a recommendation in those sections to include an as appropriate on whether there would be required symbols. LSO would not necessarily recommend that change. I think it could create confusion as to whether when the symbols are actually required. And it's as appropriate based on who. And so just wanted to bring that before the committee's attention, and certainly I'm sure there'll be further discussion. But other than that, I would stand for any questions from the committee.
Any questions, committee? Representative Hunter.
Oh, there it went on.
Thank you, Mr. Chairman. Mr. Plum, on page 3, line 7, it says the operator of one of these implements or tractors or manufactured equipment must possess documentation published or provided by the manufacturer. Why is this required to have that documentation with the tractor at all times? Being on a tractor myself, they just get dusty and dirty, and to carry that documentation, that's going to be difficult for the rancher or farmer to be able to do that. Just what is the reason for that?
Chairman, Representative Heiner, I think that was based on a recommendation from the agricultural. It's mostly for these vehicles that can reach speeds over 25 miles per hour. I think that's a point well taken. That was included in the Ohio statutory language that I kind of was modeling this after. I certainly think that is a committee decision. If you'd like to have that included or not. Oh, and I'm sorry, Chairman, and I would just note, I do believe that actually it is Mr. Kennedy suggests deleting that from this bill. So there may be further discussion from him as well.
Okay. Thank you. All right. Come on up, Keith.
Thank you, Mr. Chairman. And I won't sign on to the Zoom to show you a slide unless we need to do that to explain a portion of the amendments that I've suggested. And Mr. Chairman, with your permission, I would go back to that last question that Representative Heiner asked. Thank you, Mr. Chairman. I contacted the 3 largest equipment manufacturers that sell ag equipment in the United States. And all 3 of them told me that the documentation that they provide is the speed identification symbol. So there is no further documentation on on an implement that would have that symbol installed on it. You might recall that there was, with your permission, I would like to just go immediately to the amendments that I had proposed, unless there are other questions before we do that, Mr. Chairman.
I'm good with that. Looks like we're good. Go ahead.
Thank you, Mr. Chairman. The first one is merely technical, and that would be on page 2, line 13. The professional society since 2007 has been the American Society of Agricultural and Biological Engineers. The next one is also on page 2, line 17, where we would recommend striking manufactured, and because these pieces of equipment have been in operation now, the standard was actually adopted in 2008, and there are implements, tractors that are being operated today. I can take you to 4 of them within 2 miles of this location at 2 different ag retailers, where they have application equipment that's rated to travel 30 or 35 miles an hour and has the symbol on it. So I would recommend striking manufactured and. I did not mention this in the amendments, but on the top of page 3, although I have not seen it, there is equipment, or our equipment, I guess would be a better way to put it, which is the speed information symbol is denominated in kilometers per hour because of its origin. There is no requirement in the ASABE that it be denominated either in miles per hour or in kilometers. But from what I was able to find in my research, if it is in kilometers per hour in the US, it's noted on the speed information symbol. So there would be clarity for law enforcement that yes, this is in kilometers rather than miles per hour. And as I mentioned earlier, from line 7 through line 11 on page 3, we would recommend, and the amendment speaks to deleting that, and we would add the words, a speed information symbol shall be present. Further on the bottom of page 3, line 20 through 22, we would recommend deleting through up to the word towed in line 22 and insert any towed unit shall be equipped with a slow moving vehicle emblem. Specifically, because these sections are dealing only with those vehicles allowed to travel over 25 miles per hour. And I would agree that the term as appropriate is ambiguous. I had thought about that since I sent this in, and I believe as determined by the equipment manufacturer would be appropriate language to insert there rather than as appropriate. That makes it much less ambiguous. The society's recommendation is that all equipment in a combination has the appropriate symbols. So although I proposed an edit to Romanet 2, I believe that section could be deleted if you wished, but the language where we
hang on a second, I'm lost.
Okay, pardon me, on line.
Where are we at? What line?
We're on page 4,
Oh.
line 7.
Okay,
We could.
thank you.
It would, thank you, Mr. Chairman. It would solve that problem to delete then either or that Romanet 2 could be deleted in its entirety. And then the language that we would propose being added is in any combination of tractor equipment or implement, the upper operating speed on a public street or highway is the lowest speed information symbol displayed on any portion of the combination. If only a slow moving vehicle emblem is displayed on any portion of the combination, the combination may not travel over 25 miles per hour. So if we have a towing tractor with 2 wagons behind it, one that would just have a slow moving vehicle emblem on it limits the entire combination to 25 miles an hour. And in the case where they all had a speed information symbol, it is the lowest one present. And as I've done more research on this, there are implements sold in the US that are rated 30, 35, 40, and 45 miles per hour. And so I think this is a worthwhile addition to the bill. And with that, Mr. Chairman, I'd welcome questions from the committee.
Committee questions? Representative Fortner.
What do you do with the equipment that don't have a slow mileage decal on it? Is that going to hog tie people up that have equipment that does not have the decal on it like that? Or is they just going to be accepted, grandfathered in at that stage?
Well, Mr. Chairman, I'm old enough to have tied one on with baling wire on the back of the rake tractor. And as time has gone by on most farm equipment now, these are integral. They're installed to a portion of the vehicle. Now, as to shop-made equipment that an individual may make, I think they're kind of responsible to install that. And part of what equipment manufacturers have done with much of this equipment that may be rated to travel at a higher speed is a change in the strength of the axles as well as the bearings and races that are installed on the wheels. It's the primary difference that they make. But I would also add that most of the larger towed equipment now also has braking systems installed too that are essentially the same thing as plugging your airlines into your semi trailer as well. So the manufacturer is certainly at risk, liability risk for vehicles that they rate to travel at any speed.
Committee, any other questions? Okay, thank you.
Thank you, Mr. Chairman.
All right, we have the Highway Patrol on the line. Okay, could you bring them in, Katie?
Good morning, Mr. Chairman. Can you hear me?
Yes, go ahead, sir, when you're ready.
You bet.
And welcome to the Ag Committee.
Thank you, sir. It's an honor. We don't get an opportunity to interact often with the Ag Committee, so thank you for that. Shannon Ratliff with the Highway Patrol. Mr. Chairman, I don't know that we have a lot to offer. I think we're going to remain fairly neutral on this draft legislation as well as Mr. Kennedy's proposed amendments. I would make a couple of observations, however, if I may. We looked into this. There are really 2 states that do this and have been doing this for some time now. And I believe those 2 states are New York and Ohio. We've taken a look at what surrounding states are doing, and they're not utilizing this speed symbol. Mr. Kennedy mentioned a strikeout of manufactured and on page 2, line 17, which I believe will bring in all tractors, not just those manufactured after July 1st of 2023. So that would certainly include any tractor that is capable of traveling faster than 25 miles per hour. If I'm reading that correctly. And then, Mr. Chairman, I think we would be a little bit concerned with the speed in kilometers per hour versus miles per hour. I think that may provide some confusion. Although, I mean, I would certainly offer that I'm guessing that most of the motoring public, most of the law enforcement have no idea what an SIS is. And we would, we would obviously do some educating of our own officers. But would just offer that as well, I guess, and I would answer any questions, Mr. Chairman.
I've got a quick one. You said other states are not utilizing the slow moving vehicle signs. I don't think I understood that. I probably incorrectly understood it.
Mr. Chairman, my apologies. I believe most states are using the triangle slow moving vehicle emblem or symbol. However, the SIS that would accompany a tractor or implement that would move faster than 25 miles per hour, we're not finding anyone else except New York and Ohio using that round symbol with the speed indicated, the max speed indicated.
Okay, thank you. I just misunderstood some things. Yeah, Representative Larson.
Mr. Chairman, thank you. Do you have data on if there's been citations written for traveling over 25 and having that symbol? And yeah, thanks.
Mr. Chairman and Representative Larson, are you speaking to data in Wyoming or those other states as well?
Mr. Chairman, data in Wyoming.
Mr. Chairman, thank you, sir. I don't, but I will tell you just anecdotally, I mean, and we can certainly look into that, but I will tell you anecdotally that our officers, about the most they're going to do is if they see a tractor with a slow moving vehicle emblem on it that is loaded onto a trailer that is moving faster than 25 miles per hour, will stop that vehicle. Or if that scenario comes through one of our ports of entry, they'll be told to cover the sign. We don't take enforcement on that.
Okay. Let me go here first. Chairman Boner.
Hey, yeah, so thank you, Mr. Chairman. So we just got these amendments from the wheat growers this morning. Have you had a chance to review those? And just want to make sure that you don't see any red flags. It looks like the idea of using kilometers per hour is just a kind of a suggestion at the end. It's not an actual amendment. So I'll make sure you've had a chance to review these amendments, as the committee frankly hasn't had much of an opportunity to do so. Just want to make sure that you don't see any problems with those proposed amendments from your end.
Mr. Chairman and Mr. Co-Chair, yes, I've had a chance to peruse these, and correct, yeah. Other than what I mentioned, the second one there, page 2, line 17, with the striking of manufactured and, seems to me that it will loop in all tractors capable of doing more than 25 miles per hour versus what was initially suggested, which was tractors manufactured and operated after July 1st. So this would be, I don't suppose there are a lot of them, but if there's someone has an antique tractor that can go faster than 25 miles per hour and you're going to operate that on the roadway, then the slow moving vehicle symbol, the triangle, as well as the SIS indicating the max speed of the unit would be required in my estimation. Mr. Chairman, I think that was a question that was asked at a previous meeting, something similar to that.
Okay, yes. Chairman Boner.
Yeah, and thank you, Mr. Chairman. Just so we're clear, I mean, all that we're doing is we're talking about requirements for posting these symbols on slow moving vehicles. We're not saying it. I mean, if it goes 25 miles an hour or more, it's not like that's a problem. It's not like there's a speed limit for tractors or anything like that. It's just alerting the general public that, hey, this thing's going really slow. Is that correct? So all that this bill will be doing is adding additional requirements for our farmers to post that information on their farm equipment. Is that correct?
Mr. Chairman, correct. That's how I understand it.
Thank you.
Representative Fortner.
Thank you, Mr. Chairman. You say New York and one other state's already had this slow moving vehicle process in place for some time. How does this amendment look compared to what they've already had in place? Are we pretty much mirroring what they're doing, or do we need to add something to suit the highway patrol in the state of Wyoming?
Mr. Chairman, I think these amendments are certainly amenable. Again, we're pretty neutral on this. We can operate with this, and you know, other than the couple of suggestions I made, I think we're fine.
Okay. All right. I think we're good. Thank you, sir. Good to see you again.
You as well, sir.
Don't
Thank
see
you.
you much on this committee. Come on up. Mr. Moline. Welcome back to the hot chair, and go ahead when you're ready.
Mr. Chairman, Brett Moline, Wyoming Farm Bureau Federation, supporting the amendments to this bill. I think what it does is it helps clarify it. That, you know, what this bill does for the vehicles that could go 25 mile an hour or below, it essentially doesn't change the rules. You have to have the SMV sign. But those vehicles that can go, farm vehicles that can go above 25, they can only go up to the speed that they're rated to. But they still need to maintain the SMV, and it's public safety. I think it's very important. And with that, Mr. Chairman, trying to be uncharacteristically brief, I would sit for any questions the committee may have of me.
Questions, committee? Yeah, Senator Cole.
Day again, Mr. Moline.
Sir.
A quick question about the equipment itself. Is it your understanding that they're governed at a maximum speed, say at the manufacturer's maximum safe operating speed, or can they go higher? And
Mr. Chairman, that might be a question for other folks. Typically on the farming equipment, I don't know if I would use the word governor. They're not like a big truck that has the actual governor on it, you know, but they're between the gearing and the speed. I think that's probably the biggest limiting factor. And you know, and what this is saying is that, you know, if they're rated to go 35, that's all the faster they can go legally. I hope I answered your question, sir.
Follow up, Senator.
yeah, and then on the metric system going on here, I guess could you explain why you think it's something the general public would have a grasp on? Because it seems to be for them, the symbol about how fast a vehicle can go in front of them. So I think I don't know why it wouldn't be confusing for someone to see kilometers per hour instead of miles per hour. You know, it may seem more clear to me in the US that would be a better way of posting it on a vehicle. What's your opinion on that?
Mr. Chairman, Senator, you know, the decal that would list the speed, being it in kilometers or miles per hour, I think is of less importance than having that slow moving vehicle sign. That's what draws your eye to alert you. And I think that's the most important part of it. For the general public, the miles per hour would be more understandable, but I think that the big thing is the vehicles having that slow moving vehicle decal signage on them to help alert. That's the big one to me, sir.
Okay, I guess a question I'd ask on that if we're gonna do that, because miles per hour is what I just don't want to go through a metric conversion every time I have to, but could we, if we're going to include this, have both, just have miles per hour and kilometers per hour in parentheses or something? Do you think that'd be appropriate, or is it?
Mr. Chairman, my gut reaction is whatever comes out standard on these vehicles, be it miles per hour, kilometers per hour, would be the appropriate language in this. And I think perhaps the easiest thing would be to do an and or,
Okay.
kilometers per hour or miles per hour. Because again, I think it's important to have that information to show that, well, this vehicle, the reason it's doing 30 instead of 25, if it's capable of doing it. It's not a Ford 8N, it's a newer model of a vehicle that is, a sprayer that can do that. But, to have it, that it needs to be designated on the vehicle, and then have it that, kilometers or miles per hour. But I think the most important aspect of this is getting these slower mover vehicles that can do over 25 to have the SMV signage on them. That's the alert. That's what shows. That's what people are used to. They see it and they understand they're going to be coming up on them much more quickly than they would when I'm doing 45 in my car.
Okay. I'm starting to understand this kilometer deal. We have some European made tractors that are probably going to be in kilometers per hour is what we're talking about. Okay. All right, committee, are we finished with Mr. Moline? I think we are. Thank you, sir. Any further? Yeah, come on up, Keith.
Mr. Chairman, Keith Kennedy, Wyoming Ag Business Association. I'll throw on a different hat. The reason I suggested the deletion of the manufactured and is there are implements that have been manufactured in 2012 that have a speed information symbol at 30 miles an hour. And we can go to a couple of locations here in town where we can find those sprayers right now. Are they out on the road doing long distances? No, because it's too expensive. It's hard on tires and so forth. But when they move from field to field, a mile or two down the highway, they routinely travel 30 miles an hour. And I would assure the committee that in Kansas or Nebraska, you'll readily find these and nobody's ever found an issue. We just felt like it was time to update this statute, and perhaps I should have just shut my mouth and nobody would have been any wiser. Would also have worked, but based on the fact that I almost always get a call from a retailer during the spring from a new state patrolman that isn't familiar with the rules for implements of husbandry, why we felt like it was time to update this. And with that, I'd welcome any questions you all might have.
Questions, committee? Thank you. Any further public testimony? Anyone online, Katie? All right. We'll close public testimony. Committee, what's your pleasure? As amended. Okay, now we maybe need to clarify some of these, which part of the amendment amendment we've changed. Okay, the bill has been moved and seconded. Let's talk a little about the amendments, which, go ahead.
Okay, Mr. Chairman, I move that we amend the bill as denoted by the wheat growers with the exception of their suggestion on line 2, line 17. So we'll keep manufactured in there for now.
So just leave that in there.
If I get a second, I'll explain.
Okay, is there a second? Been moved and seconded. Go ahead and explain.
Okay, so Mr. Chairman, I just think that, since we didn't coordinate this with Highway Patrol beforehand, it's important we take their input as well. I'd rather cast a smaller net than a larger net, and you don't want to get anybody who has maybe an older tractor that happens to go over 25 miles an hour that isn't maybe all that new. It doesn't have a symbol. I'd rather not, put an owner's requirement on them that's unreasonable. So till we get more information, I just want to keep that part out.
Okay. Committee, are you clear? Okay, so we will, oh, I'm sorry. Go ahead, Representative Heiner.
Thank you, Mr. Chairman. Part of the conversation was around kilometers versus miles per hour. And it's my opinion that we live in a country that has embraced miles per hour. All of our signage is that way. I do not feel like we should add kilometers as an option. It should be miles per hour only. Thank you.
Okay. Yep, go ahead.
And
Senator
just to be
Boner.
clear, I don't think that's that's not incorporated in the amendment. So that'd be an additional amendment if we want to have that conversation, though I'm inclined to agree with Representative Piner. But just to be clear, that's not a part of the motion right now.
Yeah, it's not part of it, but the reason it could be pertinent is because we have manufacturers that'll send a tractor directly from Europe and it probably won't have miles per hour. So that's why it's denoted here. But we'll leave it out for now and maybe modify the bill if necessary later, I think. Go ahead, Vice Chairman Clausen.
Mr. Chairman, just clarity from the bringer of the amendment, page 4, line 8. You had some suggestions instead of as appropriate, to change the language to determined by manufacturer. Was that part of your motions?
I believe it is. isn't it?
Yes.
Yeah, okay. It is. So does everybody understand that as appropriate is a little ambiguous, so we'll go with as determined by the manufacturer in both places. Page 4, line 1 and page 4, line 8. Correct? Go ahead, Chairman Boner.
And Mr. Chairman, just want to clarify with staff if that would take care of some of the concerns they had with the proposed amendments, or if there's additional modifications we need.
Thank you, Chairman. Sorry, one second. Thank you, Chairman. I think that certainly would work if you wanted to include as determined by the manufacturer. I guess I assume the intent is, that the towed unit shall be equipped with a slow moving vehicle emblem and a speed identification symbol as determined by the manufacturer in terms of the speed the vehicle can reach, right? I think that's the intention there. Excellent. And just while I may have one moment, I just did want to say on page 4, line 8, it suggested that they after emblem insert a comma. I don't believe that's within LSO's traditional drafting practice. I know that's a small thing, but just wanted to address that as well.
Sure. Yeah, either way, it's good. All right. You have more? Oh, yes, Heather, go ahead.
Mr. Chairman, additionally, just to be parallel with the above, that it seems that like rather after, instead of on line 8, page 4, line 8, after emblem, having it be after symbol, like it is up on line 1 would be the suggestion. And then also the committee was saying that kilometers per hour was not a part of the bill draft, which is completely true, but miles per hour are in the bill draft. Just want to make sure the committee did know that.
Okay. Sensing we're ready to vote, and I think we're clear. LSO has helped us out. All those in favor of the bill as amended? Please, no, wait a minute. I can muddle up Robert's rules. I think we're voting on the amendment first. I'm sorry. All right, so we don't have to have another meeting to fix this. All those in favor of the amendment? Please say aye.
Aye.
Opposed? All right, the amendment is passed. Are we ready to vote on the bill? All right. No, we're not ready.
Okay.
Go ahead.
Just
Chairman.
before we go ahead, just want to make sure, we got these amendments today. Want to check with staff that the bill as amended right now, it's okay, it's good to go. And we'll have leeway for minor grammatical things or technical things. Just want to make sure there's no additional amendments that we need at this point.
We don't have. Break for lunch. Oh, are we really? Are we gonna eat lunch then? Oh, dear.
Chairman, I apologize for the delay. Thank you for that moment to look at it. Yes, it is my understanding. I think that will cover everything that was discussed, and I think that should cover all the amendments that are made. I think we understand now, and it should work.
Right. Committee, now sensing that we're ready to vote, all those in favor of the bill as amended, please say aye. Oh, this has to be a roll call. Yes, it does. Okay, roll call, Katie.
Mr. Chairman, this is a roll call vote for 23 LSO 0135 slow moving vehicles amendments as amended. Senator French excused, Senator Kolb.
Aye.
Senator Cost,
Aye.
Senator Wasserberger. Representative Blackburn. Representative Clausen.
Aye.
Representative Fortner,
No.
Representative Heiner. Representative Larson,
No.
Representative Western excused, Representative Worf.
No.
Representative Winter. Co-Chairman Boner,
Aye.
Chairman Eklund.
Aye.
9 ayes. 2 excused. 3 no.
Okay. This bill passes. Bill draft passes. We're a little bit mixed on this decision, but I think we better break for lunch. We're probably an hour behind. So we'll and I'm sorry for the inconvenience to everybody, but we'll try to do this as quick as we can. An hour is really about all we better use up. And we'll see you at 1.